Good morning, everyone, and thank you for being here to discuss several important bills regarding public safety. I'm Councilmember Yusuf Salam, Chair to the Committee on Public Safety. I want to recognize the members of the Public Safety Committee who are here today. We have with us Councilmember Mate and Councilmember Holden. We are here to examine four bills that address transparency, accountability, and the public's right to information regarding NYPD's operations. First, we will hear Intro 1237, sponsored by Councilmember Felice, legislation that requires NYPD to regularly report comprehensive data on all criminal complaints and arrests. This legislation goes beyond tracking clearance rates for specific crimes that the NYPD is required to report on and make it possible to track all crimes and the outcomes of the responses to those crimes. Although the NYPD publishes complaint and arrest data sets, we have on Zoom Councilmember Osei. Although the NYPD publishes complaint and arrest data sets, individual crime reports cannot be matched to their corresponding arrests or case outcomes, which prevents calculation of case level clearance rates and limits the public's ability to assess investigative performance across crime types or precincts. Intro 1237 aims to provide New Yorkers with a clearer picture of crime trends and police enforcement practices. The committee will also hear Intro 1402, sponsored by myself, which requires the NYPD to report on its compliance with the State Freedom of Information Law. New Yorkers rely on FOIL to obtain information about police activity, policies, and incidents. However, reports have However, these reports have documented chronic delays, excessive use of extensions, and the frequent lack of timely or substantive responses. Intro 1402 would establish reporting requirements to detail how many FOIA requests the NYPD receives, how long they take to process them, how many are denied, and the reasons for those denials. This information will help us understand whether the department is meeting its obligations under the state law and where bottlenecks or structural issues persist. The committee will also hear Intro 1451, sponsored by the Speaker Adams and Public Advocate Williams. Legislation requiring the NYPD to provide the Civilian Complaint Review Board with direct access to body-worn camera footage. Body-worn cameras were introduced to promote transparency and accountability. Yet the oversight agencies tasked with reviewing police misconduct complaints often face significant delays in obtaining footage. The CCRB has stated repeatedly that delayed access inhibits timely investigations and in some cases impedes its ability to substantiate misconduct. The NYPD, for its part, has raised logistical and privacy concerns. Intro 1451 seeks to create a clearer framework for direct access, along with establishing rules on notifications, redactions, and the protection of sensitive information so that oversight can occur promptly and effectively. Finally, the committee will hear Intro 1460, sponsored by Councilmember Brewer. This legislation regarding public and press access to encrypted police radio communications. Journalists and emergency service organizations rely on dispatch information to respond quickly to unfolding events, to verifying facts, and to provide accurate public safety reporting. Community groups have raised concerns that sweeping encryption without clear rules may obscure critical information that keeps the public informed. Intro 1460 would require the NYPD to adopt a formal radio encryption policy, ensuring that most dispatch communications remain accessible in real time for credentialed journalists and emergency service partners, with a short delay for the general public. Sensitive information, such as criminal investigation techniques or confidential sources, would remain protected. We look forward to hearing testimony today from the NYPD, the CCRB, legal professionals, journalists, advocates, advocacy organizations, and members of the public. With that, and also we have been joined by Councilmember Caban. With that, I'll turn to the sponsors of these bills for remarks and thank my colleagues and sponsors of these bills and all those testifying today. No. Actually, seeing no sponsors here today, right now. Thank you all for being here and for your engagement in this very, very important conversation. Yes. So I'll now pass it to council to administer the oath.
Good morning. For testifying for NYPD, have Deputy Commissioner of Legal Matters, Michael Gerber. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee and respond honestly to council member questions? Thank you. You may begin your testimony.
Good morning, Chair Salam and members of the council. My name is Michael Gerber, and I am the Deputy Commissioner of Legal Matters for the NYPD. On behalf of Police Commissioner Jessica Tisch, I thank you for the opportunity to testify regarding the 4 bills being heard today. Intro 1237 would require the department to disclose certain historical data to the public regarding criminal complaints and arrests, and to periodically update the data set going forward. While we already disclose extensive data regarding criminal complaints and arrests, we appreciate the benefit of connecting complaint information and arrest information. We would only ask that the update to the data set be annual rather than quarterly. The department otherwise has no objection to this legislation. Intro 1402 would mandate that DOI issue an annual report regarding the department's compliance with FOIL requests. The department has no objection to the proposed bill. In the event that it becomes law, the department will fully cooperate with DOI in connection with the annual report. Intro 1451 would direct the department to give the CCRB direct access to the department's body-worn camera system. The fundamental problem is that in order to comply with this bill, the department would have to violate state sealing laws. We cannot do that, and I respectfully submit that the City Council should not put members of the NYPD in a position in which they are being directed by city law to violate state law. When a criminal case is sealed pursuant to one of several state statutes, the CCRB is not permitted to access those sealed records without a waiver from the defendant. Sometimes the CCRB obtains a waiver. We provide the CCRB with the sealed materials in a way that is no different than any other case. In the absence of a waiver, the NYPD has to redact any sealed information before providing it to the CCRB. For example, if the CCRB needs body-worn camera video, and a portion of that video depicts an arrest that was subsequently sealed, the NYPD must redact the defendant's face, voice, and any other identifying information before providing it to the CCRB. Providing the CCRB with direct access to the body-worn camera system means giving CCRB sealed records without a waiver and without redactions. That would violate state law. Unless the state law changes, we cannot legally give CCRB direct access to our body-worn camera system. I have been speaking about the legal problem with the bill, but I think it is important to make an additional point. The NYPD and the CCRB have been working collaboratively and successfully for years to ensure that the CCRB gets the material it needs. Unredacted video is typically produced to the CCRB in a little over a week. If video needs to be redacted in compliance with the stealing statutes, the CCRB will have that video on average within 1 month. The CCRB is getting these materials in a timely manner. That said, We would welcome the opportunity to work with the Council to address any concerns that it has about the production materials to the CCRB in a manner consistent with state law. Intro 1460 would require the Department to adopt a radio encryption policy. Radio encryption is critical for officer safety. It stops criminals from monitoring our radio frequencies, which could enable them to evade capture, or even worse, ambush an officer. It prevents individuals from interfering with our radio communications in a manner that puts our officers and the public in danger. It also ensures that confidential, private information regarding victims and witnesses is not disclosed to the public. For these reasons, the Department has encrypted most of its radio channels. At the same time, there is an important interest in transparency and reporters' ability to respond in real time to breaking news stories. That is why the Department has not encrypted and will commit to not encrypting a key radio channel utilized by the Department known as Citywide One. Reports of all critical incidents are automatically broadcast over Citywide One without encryption, even when they are also broadcast over other encrypted channels. This includes, among other things, any report of a shooting, a robbery in progress, a call for assistance by a police officer, a water rescue, an active shooter, an explosion, a police mobilization, and any large-scale or unusual incident. We believe that maintaining Citywide One unencrypted addresses concerns from journalists and creates a wide range of transparency while ensuring that sensitive operational matters or confidential information is broadcast over encrypted channels. Intro 1460, as presently drafted, takes a different approach. It would require the Department to adopt a policy under which all radio communications across all channels would be accessible in real time to professional journalists and emergency service organizations and to the general public on, at most, a 10-minute delay, with sensitive information redacted as necessary from each radio transmission. That is not possible. In 2024, the Department generated over 4.3 million radio runs, or more than 11,500 radio runs per day. Making very conservative estimates, and assuming that each radio run has only 10 transmissions, each lasting 3 seconds, the Department would have to review 36,000 hours of audio per year for sensitive information, or 99 hours per day. We hope to work with the Council to craft a radio encryption policy memorializing the approach being taken by the Department, which ensures real-time transparency and press coverage in a manner that is workable and does not compromise officer safety or individual confidentiality. Thank you for the opportunity to speak with you today, and I look forward to answering any questions you may have.
Thank you for your testimony. I'd like to mention that we've been joined by our public advocate, Jumaane Williams, and we've also been joined on Zoom by Councilmember De La Rosa. I'll now pass it to our public advocate for his opening remarks.
Thank you so much, Mr. Chair. Thank you so much for being here, representing the administration. As mentioned, good morning. My name is Jumaane Williams, public advocate for the City of New York. I'd like to thank Chair Salam and the members of the Committee on Public Safety for holding this important hearing. Every day, NYPD officers across the city record potentially hundreds of hours of body-worn camera, though police are not required to record every interaction. There are many instances when they must turn on the cameras. This footage often becomes important evidence in misconduct investigations. However, the CCRB, Civilian Complaint Review Board, does not have direct access to this footage, and instead must request it from the NYPD. BWC, or body-worn camera footage, is especially crucial as there have been numerous documented cases where officers have lied under oath to the CCRB about their actions. Even in cases where officers have not intentionally lied, memory recall is unreliable, and video footage is often the best way to accurately learn the sequence of events. Timely access to BWC footage is critical during CCRB investigations, as the statute of limitations to bring misconduct charges against officers is 18 months. Until recently, the NYPD refused to provide evidence later than 60 days before the statute of limitations as a matter of policy, effectively taking 2 months off of the timeline. NYPD has historically purposely thwarted misconduct investigations by refusing to cooperate, such as withholding important evidence like body-worn camera footage until the statute of limitation has passed. A notable example of this tactic was the NYPD killing of Kowalski Trawick, a man experiencing a mental health crisis in his home. It took so long for the department to turn over the BWC footage that the CCRB brought charges to the NYPD 3 months after the statute of limitations. Introduction 1451, introduced by Speaker Adams, of which I'm a prime co-sponsor, would grant the CCRB direct access to all BWC footage. It is imperative that we close one of the many loopholes that NYPD exploits, often exploits, I should say, to avoid being held accountable for misconduct. When officers know it is extremely unlikely that they will face real consequences for misconduct, it creates a culture of abuse with impunity. Last year, the NYPD cost taxes over $205 million in misconduct lawsuits. I think we can all agree this money would be better spent on other things. In addition to giving the CCRB direct access to evidence, we must empower the CCRB. We must change the way that the disciplinary recommendations get done, particularly with the commissioner being the sole person that can change any recommendations. That's probably for another hearing. I'd love to talk about that some more, and ensure that the CCRB has the funding and staff necessary to complete all investigations for misconduct under the jurisdiction. Today, the Council is also hearing Intro 1460, introduced by Councilmember Brewer, and in which I am also a co-sponsor, which would preserve unencrypted access to NYPD radio communications. This bill would still protect sensitive information, but ensure that professional journalists and emergency services organizations still have real-time access and the public have time-delayed access to the communications. In 2023, the NYPD began encrypting its radio communications without a transparency plan implemented first, breaking a nearly century-long practice of allowing the press and the public to listen and learn about events in their communities. Combined with frequent delays and denials of public records requests, encrypting radio communications make it harder to conduct oversight of the NYPD. The state legislature agrees that this transparency is critical. In June, the state passed the Keep Police Radio Public Act, which preserves access to communication for the press. This is the first I'm hearing about citywide one, so I'd love to learn more about how that allows access. I know in other places they have allowed encryption with some delays, so I'm not fully understanding why we can't do that. But I urge the council to pass Intros 1451 and 1460, and if necessary, override a mayoral veto from Mayor Eric Adams, before the end of this session. The NYPD is trusted with the power and the responsibility to keep New Yorkers safe, pursue justice and accountability, and transparency must always balance this power. Robust checks and balances make us all safer. Last, I'd like to say, I was hoping to have better conversation around this with this administration. I find that administration has made things more opaque and less transparent. I know today it was announced that Commissioner Tisch will remain as the commissioner of the NYPD. Personally, I think she actually has done some very good things. I have been concerned about a couple of decisions, particularly when it comes to the Alan Felice case and the upcoming Darrell Smalls, Wayne Isaacs case. And I hope if this is the direction we're going in, when it comes to the Wayne Isaacs case, the commissioner will make the right decision so that we can understand we're moving into a new space of accountability. And also with these, hopefully we can have some very good conversations and move through this with some of the less acrimony that we've seen in the past. Thank you so much.
Thank you.
Sorry, Commissioner, I should have added congratulations to Commissioner Tisch.
Got it. Thank you. So I want to start up with asking about Intro 1237, complaints, arrest, and clearance rates. When a New Yorker files a complaint, maybe after something traumatic happens, how do they currently find out what happened with that case, and what does that experience feel like for them?
Well, I'm not sure I'm exactly the right person to answer that question, but I'll do my best. So what should be happening, right? If a complaint report is taken, right? The detectives investigating that matter, they should be in touch with the victim, right? They should be keeping them apprised. There are times when that's done via community affairs officers. Often, it's detective, him or herself, who's in touch with the victim. Obviously, that's important just in connection with the investigation, but then also keeping them apprised of the development of the case. To the extent an arrest is made and there's now a pending prosecution, that contact may be with the detective. It may also be with the relevant ADA. Right, an ADA should be, of course, in touch with the victim and keeping that person apprised. And I would just say more broadly that, to the extent individuals have concerns about what's going on with their case, it's very important they be able to reach out to the local precinct. And again, whether that's the detective assigned, that detective supervisor, member of community affairs, they can hopefully address any questions they have. Now, I think we talked about this actually at a prior hearing. There always is, or there often can be, a balance. You want to tell the victim of a crime as much as possible, consistent with the integrity of an ongoing investigation. You also don't want to give incorrect information. You don't want to say there's going to be an arrest if there isn't going to be an arrest. So that there's always that balance. And then, Chair, you asked about what's the experience like for an individual who's been the victim of a crime. Obviously potentially incredibly traumatic. I think one of our many obligations is not only investigating criminal activity, but trying to give the victim a sense that we're doing everything we can to achieve justice for that person.
Thank you. We hear from families who say that they never know whether an arrest was made. How will this bill help to restore trust by giving people closure? So,
first of all, if the family of a victim does not know what's going on in a case, that's obviously not okay. It's not acceptable. They should be reaching out to the local command, and to the extent the case detective or the supervisor is not keeping them apprised, that's a problem, and that should not be happening. Now, the bill, does it address that issue? I guess to some extent, because I guess the idea is, well, you're going to be seeing on a particular complaint, you'll be able to sort of see, for this particular complaint, was there an arrest? So someone can, of course, could look at their particular complaint, potentially, and sort of see, oh, is there an arrest here? But I have to say, I think the crucial piece here, to the extent the concern is about responsiveness from the department, we need to be responsive. We need to be following up with victims. And if victims are coming to us, we need to be getting back to them and telling them whatever we can. I think that's really the answer. I think the data is important for understandable reasons. But I think I'm not sure that the answer, to the extent there are victims of crime or family members of a victim who feel like they're not getting enough information, that's something we need to address. But I'm not sure the reporting bill really gets at that ultimately.
Okay. Right now, the public database, or data sets rather, don't let us match a complaint to the arrest that clears it. From your perspective, why has this been so hard to make it transparent?
I'm not sure that it's been so hard. We obviously already report a lot of complaint data and arrest data, and because we're obligated to do so, or something that we've already decided to put out to the public. The bill requires us to put out data that links those two things. And as I said, other than the sort of reporting time period, quarterly versus annually, we have absolutely no objection to that. I also should say that, for several years now, we have been reporting clearance data that is based on arrests cleared in the relevant quarter, right? So historically, the clearance data was, for a given quarter, total arrests divided by total number of complaints for a given crime and for a given borough in that quarter. So it was total arrests over total complaints. Now, this has been true for several years. We put out, we put out quarterly data that gives clearance rates and calculates those rates in various ways. So we have the old calculation and we have the new calculation. And that new calculation, I do want to emphasize, that new calculation is, okay, let's say it's robberies in a particular borough. all right, there were, X number of robbery complaints in this quarter. For those robbery complaints, how many arrests were there in the quarter? So that data is out there, has been out there for several years. But I understand that with this bill, you'll have both going forward and historical data that actually allows, actually links up the particular complaints and the particular arrests.
Are there crime categories where victims almost always wait longer for answers, and what explains this difference, if there are?
I'm not sure about that. I mean, it really depends. I would say it depends much more on just the nature of the particular crime and the circumstances and the evidence, right? There are crimes where immediately, sometimes there's an immediate arrest, right? Sometimes patrol is making an arrest right away. There are times when there's a lot of evidence for a variety of reasons, and we're able to move quickly and make a quick arrest. There are times when, for reasons totally beyond our control, there may be very little evidence. And the detective bureau, the detectives are going to work incredibly hard, and they are incredibly talented to solve those crimes. They have to work with the evidence that they have. So I don't know that it's really about a particular crime type as much as, there are times when, given just the circumstances of the crime and the evidence available, there will be a quick arrest. There are times when, as good as our detectives are, it's going to take a lot longer to solve that crime. And as you know, there are situations in which crimes go unsolved. Despite our best efforts, despite incredibly hard work by detectives, sometimes the evidence just isn't there. That happens.
How would clearer data actually help detectives on the ground, especially in precincts that are under-resourced or stretched very thin?
How would data help?
Clearer data.
Well, I don't know that I don't think the work of the detective bureau and the individual detectives is really driven by the sort of data we're talking about here. What I mean is they're committed and they work every day to solve crimes. They're doing their very best. There's a tremendous amount of oversight, obviously. And I frankly, a part of ComStat, which is sort of the central hub of so much of our crime work, is about looking at the work of the detective bureau, particular squads, what's work that's being done on cases, to the extent we find cases where the leadership of the department, the enforcement side leadership of the department, feels like not enough work has gone into it, or there's been a failure to follow up on things. Supervisors are going to hear about that, and they're going to push very hard on that. So there's a lot of effort and focus that goes into making sure that our detectives are doing everything they can to solve crimes to the best of their ability, consistent with the evidence, consistent with the law. I don't know that Intro 1237 really goes to kind of how the detectives view their work. I think Intro 1237 is about transparency with the public, additional data for the public, analysis that can be done by researchers or by other members of the public.
And we often hear that clearance rates are affected by witness cooperation. What supports could improve these outcomes aside from staffing?
Sorry, Chair, could you say, I didn't hear the question. You could just, I'm sorry.
Sure. We often hear that clearance rates are affected by witness cooperation. What supports could improve these outcomes aside from staffing?
Right. So, I first want to say it really does depend on the nature of the crime, right? There are certain, you can easily imagine fact patterns where witness cooperation is going to be absolutely crucial, dispositive, right? You have a key witness, there otherwise isn't a lot of evidence, and whether that person is cooperative or not is going to make all the difference in the world. There are other circumstances in which our detectives are able to gather lots of other evidence. There could be forensic evidence or video evidence, and can build a very strong case, sometimes even without certain witness cooperation. So it really does depend. And then with, one of the things that we need to do in every case, and it goes to a question you asked earlier, is about, being in touch with victims and witnesses, following up, engaging, building trust with them. That's all crucial. And that's something that our officers and our detectives do every day.
I want to move to intro 1402. Everyday New Yorkers tell us that FOIL feels like a black hole. You send a request and hear nothing for months. Do you recognize that experience from inside the department? Is it different, or is it?
So, I can certainly appreciate why some people might experience it that way at times. I think we have had a real challenge with FOIL, and just in candor, right? So, from 2018 to 2024, we saw an 161% increase in FOIL requests to the department. So, in 2018, there
What was that
were
number? You said 100.
161% increase in FOIL requests. So, in 2018, the total number of FOIL requests we got was 14,389. That was in 2018. In 2024, that number was 37,432. So there's been an extraordinary increase in FOIL requests, and it's not just the number of requests, right? It's the number of requests and then the universe of documents, video, other things we have responsive to those requests, which also has gone up dramatically. So we're at a point where we're getting, roughly, actually maybe over 3,000 FOIL requests per month. So there's a tremendous amount coming in. Back in 2023 and then in 2024, we did increase the staffing in FOIL, but it wasn't enough to keep up. So part of the answer has to be, on our end, further increasing FOIL staffing. We are taking a lot of steps to make that experience easier for New Yorkers. Chair, to your question, the reality is most of the FOIL requests come in over an online portal, right? We do have people who call, we do have people who walk in, and when people call or walk in, we always have someone who's responsive and helps walk them through the process. It is easier administratively, obviously, if it's through the portal, just in terms of tracking things and following up. So to the extent someone's calling or emailing, I think I would expect them to find someone who's available to help them and walk them through this. In terms of getting back to people, there is a tremendous range. And that depends often on the nature of the request. If someone is asking, someone says, hey, I would like a complaint report. That's it. We should be able to turn that quite quickly. It's discrete, it's one document, it's straightforward. We also get requests that are massive, voluminous requests for records going back many years. Documents that are in hard copy, that are going to require review for FOIL exemptions or redactions, and that's going to take a lot longer. So I think our FOIL team is working incredibly hard in a challenging situation, just given the sheer volume of what we have coming in. I do want to say, and I know I do appreciate there are times when people are making requests and they're frustrated that things aren't turned around sooner. But just a little bit of data to give, I think, some context. Of the requests we've gotten so far in 2025, over 40% of those are already cleared, already responded to people. From last year, 2024 requests, we're at 77%, so close to 80%. One thing we've been focused on is, at the same time, sort of, to the extent there are requests coming in that we can respond to easily, like the request for Discrete 61, turning that quickly, while also having a separate team working on just trying to clear backlog. So one thing that we've done, that backlog team so far this year has cleared 19% of the pre-2025 backlog. So we are on it. We are engaged on this issue. We appreciate the need to clear the backlog. We appreciate the need to turn requests as expeditiously as possible. Again, a part of this is getting more resources for FOIL, and we're going to make that request again in the upcoming preliminary budget to increase FOIL staffing.
Just out of curiosity, does the department use AI to help them in some of these gaps?
No. So I think there's a lot of We certainly think about kind of ways that AI could help. And there are conceptually so many areas where AI could be helpful, obviously, but we also have to be very deliberate and thoughtful about this. How we use AI, making sure we're doing it in a way that's rigorous and careful. We don't want this to be a haphazard approach. The department needs to think about AI holistically across the department. What are the policies? What are the procedures? And that is certainly a project that we need to be working on long term. So, is there going to come some future date at some point when AI is able to help us address a variety of issues? Yes, I think so. But that day is not today. And so, AI is not going to solve this problem now. And to your point, if individuals are waiting and they're frustrated, right now, AI is not going to solve that problem. So we need to work on it with the tools that we have.
And just out of curiosity as well, from the department's perspective, are there any parts of the FOIL process that cause you all frustration?
Well, I think I'm not sure about
I know the
frustration
public
exactly.
is frustrated.
Yeah,
but,
I think it's just it is challenging because the FOIL statute is a remarkable thing, right? It is. Anybody can come to a city agency and request data and documents. You don't have to be a reporter. You don't have to be an advocate. Any individual can do it, and it is, like I said, pretty extraordinary, and it's a tool for transparency. We're a large organization. There are a lot of different pieces and moving parts. Obviously, at this point, a lot of stuff is electronic, though historical records sometimes are in hard copy. And so the sheer volume and scope of FOIL requests is challenging. I wouldn't say frustrating, because that's our job, but it is challenging. In a world in which we're getting, like I said, 3,000 requests coming in every month, and the nature of things, just over time, this sort of possible universe of responsive things just grows and grows and grows, that does present administrative challenges. But I just want to say, I'm with those challenges, I am very proud of the work our FOIL team does. This is work that happens in sort of behind the scenes, right? But it is very important work, and we are really working very hard to do better in what is administratively a challenging situation.
We've been joined also by Councilmember Areola. So, when a request is delayed multiple times, what typically is the reason behind those extensions? We hear from journalists and families that appeals often get granted later. Does that suggest the first denials are overly cautious?
So there are two different things going on here. There's the extensions and then there's the appeals. I think those are really two separate issues. So just to be clear, the statute allows for extensions, and there's case law on this. The New York Court of Appeals has talked about this in a case called Data Tree, the Third Department, in a case called Save Monroe. So the fact that there are multiple extensions in and of itself is not a problem under the FOIL law. Under the FOIL law, when a request comes in, within 5 business days, you either grant, deny, or acknowledge it and give an estimate of when you will be able to decide whether to grant or deny the request. And that's totally fine, right? The idea of saying, hey, we're going to need more time is fine. And the case law is clear that you can ask for you can say, hey, we're going to do additional extensions. The question is reasonableness. When these issues get litigated, the question is this reasonable? And if you look at the case law, you look at the cases, the factors that the courts consider are kind of what you'd expect. How voluminous is the request? How complex is the request? To what extent is it going to require a lot of time and effort in terms of review and potentially redactions for FOIL exemptions? One of the factors actually that the courts look at is how many requests and how voluminous more broadly are the requests coming in to the city agency in question. in our case, incredibly voluminous. So it's a multi-factor analysis. And so the fact that there are multiple extensions and things take time in and of itself is not inherently a problem. It depends. If there are multiple extensions, it's taking a very long time to get a single complaint report. Well, that seems unreasonable, right? If there is a massive document request for hard copy documents, going back many years that are complex in nature, okay, that's going to take a lot more time, and the statute and the case law accounts for that. Now, with regard to appeals, so when the way it works, right, is if a FOIL request is denied, or if someone is, it was granted, but there are certain things that were withheld or redactions, if someone is unhappy with kind of the outcome, they first appeal internally, right? There's an administrative internal appeal. If they're still unhappy with that, they can file an Article 78 proceeding. Our appeals officer, and this is where the data gets a little bit confusing. So sometimes what happens is, because there is no fixed time frame in the statute, the requester will say, hey, it's taking too long. I think this is unreasonable. I think this is a constructive denial. You haven't denied it officially, but for me, it's taking too long. I'm treating this as a denial, and therefore I'm going to appeal. Now, sometimes the response from our own, appeals process is, hey, look, wasn't a constructive denial. This was premature. But sometimes the answer goes like this: look, this is premature, but you know what? We are going to be producing these documents eventually anyway. Instead of remanding it and letting this process play out longer, just at the appellate level, let's just give the documents now, right? So I want to be clear, that may or may not be an issue in terms of timing, but the fact that the appeals officer says, hey, give the documents now, it doesn't mean we were getting it wrong before. It means that it was taking too long for the requester. That's a timing issue, not a merits issue, if that makes sense.
How do you balance the legal need to protect sensitive information with the public's need for transparency, especially when trust in institutions is so fragile? And also, do you think the FOIL turnaround times affect public trust in the NYPD, and how do you see that playing out?
So in terms of the privacy rules, the FOIL statute has a set of exemptions. Under the law, there are certain things that we're allowed to redact, and that's what we do. In terms of FOIL exemptions or redactions, we're following the law to the best of our ability. In terms of public trust, again, I think we are doing our very best with the resources that we have right now, with the flood of requests coming in, to be as responsive as we can. We definitely need more resources. We want to get more resources, and that, like I said, is going to be part of our preliminary budget request. One thing that I have emphasized, and I think we're doing better with this, is having supervisors on the FOIL team being in contact with journalists, being in contact with advocacy organizations. We can't be in contact with everybody all the time. The volume is so enormous, that's not possible. But particularly when you have these larger requests, and then sometimes, for reporters, obviously there's time sensitivity. We want to be engaging and trying to understand, for example, if it's going to be a rolling production, is there something that's a priority for you? So you made this massive request, this is going to take some time, but is there something that you're really looking for first that we can get to you earlier? I think if you rewind a few years, I think there was a lot less of that communication. I think there's a lot more of that communication now. I certainly have had instances when I've been contacted by either advocacy organizations or journalists who were looking to sort of move things along with a FOIL request, or there was a particular piece of a FOIL request that was very time sensitive. And we've been able, I think often, not always, but often to accommodate that. I think that's very important.
I want to move into CCRB's granting the access to the NYPD body-worn camera footage. We want to know, how does the NYPD learn that a criminal proceeding has been sealed pursuant to the sealing statutes? These are actually a line of questions from our speaker, Speaker Adams.
Sure. So in our department, so in the department records, right, the arrest reports, for example, those are sealed in our system. If I mean, we rely on OCA for that information, but we have a system in place so that OCA is telling us, hey, arrest number whatever is sealed. That arrest report is going to be sealed, and that will flow through to various places where that arrest information is contained. So if you were to look up that arrest number, you would see, sealed. You would not be able to access it. So I think that may answer your question.
It does to a degree, but at what frequency does the NYPD learn that a case has gone from unsealed to sealed?
Right. So, and this is part of the challenge. So sealing, right, it changes every day. So there's a feed that we get from OCA, multiple feeds actually. I think the feed is every day. I think it's daily. It's possible I'm wrong about that, but I'm pretty sure at least some of the feeds are daily. And so then internally in our systems, in terms of the arrest report, stuff like that, that's coming in on a daily basis, and then that's going to be reflected. Again, I'm not sure if it's like literally instantaneous or it takes a little bit of time in the system to flow through, but it will flow through to for example, arrest reports that are sealed, or summonses that are sealed, or on our complaint reports, there's a section there are fields for arrest information that's going to seal. So that's how it works.
What information does the NYPD receive about a case if it becomes sealed, and does it receive the arrest number or the docket number?
So I'm not sure technically how the connection is made between the OCA data and our data. I just don't know, but I do know that feed definitely comes over, again, on a, I think, daily basis.
When a case becomes sealed, what is the process for NYPD ensuring that records related to the case are sealed in NYPD databases?
Right. So to the extent you have, like the arrest report being the most obvious document, right? If that arrest is sealed, that arrest report will be sealed. On the complaint report, if you have, a field for, arrest information, that electronically gets sealed. So this is doable in an electronic system where it can flow through, right? Hey, this is a discrete document. This is the arrest report. That arrest is sealed. This document seals. Hey, there's a field for an arrest. This arrest is sealed. That field is sealed.
How soon after the NYPD learns that a case has been sealed are the associated records sealed in the NYPD's database?
So like I said, so we do rely on OCA for that, right? I can't say what the timing is on their end. That is, how long from sealing to when it comes over from the OCA side. I'm not sure about that. That's a question for OCA. I think on our end, once it comes through, it's going to be nearly immediate. Again, it may not be instantaneous because I can't speak to, like, once it comes in from OCA, kind of how long it takes to sort of flow through the system. But it's not going to be a substantial period of time. Once OCA has notified us, those electronic fields or electronic documents that are arrest document or an arrest field will seal within our system.
Is the NYPD able to generate a list of NYPD-related cases that have been sealed? And who would be responsible for generating that list? What types of information about those sealed cases would they generate? For example, arrest numbers, docket numbers?
So, I think I'm not the data person. I'm confident that we could generate a list of, sealed arrest numbers, for example. again, the number changes on a daily basis, or near daily basis. So that number is constantly in flux. But could we generate a list of arrest numbers that have been sealed? I certainly would think so, or we could do the functional equivalent. Again, I'm not the data person, but I would assume that is doable.
Is the NYPD able to also generate a list of cases that have been assigned to family court? And if a case is reassigned to family court, how is the NYPD notified? What information does the department receive, and how frequently do they receive that information?
So again, family court sealing, there's going to be some sort of feed that's going to come over again from OCA. I'm not sure to what extent that's identical to the sort of quote unquote regular OCA feed, or has certain nuances that are different because the family court piece of it. But again, that should be flowing through any which way.
In 2021, the Office of the Inspector General for the NYPD published a report which found that the NYPD commingled sealed, unsealed, and juvenile arrest body-worn camera footage in the body-worn camera footage cloud platform evidence.com. Is this still the case as of late 2025?
It is. So it is. So this is a real challenge for us on multiple fronts. There are a few different pieces to this. So we have in our body-worn camera system over 50 million videos. And the numbers are astronomical. We don't have any available means to sort of flag the videos as sealed as that changes over time, right? So sealing can happen a day later, a month later, a year later, multiple years later. The officers who were involved in an arrest, often may not even know that a case was later sealed, right? So there's no way for them to flag that on sort of in the body-worn camera system because it happens later and they're often unaware of it. They may not even be in the NYPD anymore. It just depends. So there's no simple way or readily available way to us to just sort of to sort of capture, hey, this is a video linked to a sealed arrest. And there's another problem, and this is just very, very hard. So I was saying before that it's easy to sort of to seal things, or easier to seal things when you have a discrete document. Like this is the arrest report. Okay, this document seals. You have a field on a complaint report regarding arrest. That field gets sealed. The challenge is this: in a video, you may have a portion that seals. Many other portions of the video do not seal, in fact, are crucial for ongoing criminal investigations. And there's no way, it's not like a field on a document where you can say, okay, this space here is the arrest space, so you seal this off and the rest you use. In a video, right, you can easily imagine a body-worn camera video, officers doing exactly what they're supposed to do in terms of activation, responding to a scene, talking to a victim or victims, talking to witnesses, physical evidence and where it is being captured on body-worn camera video, and then a few minutes later, effectuating an arrest. Let's say that arrest, let's say that case is later dismissed and it's sealed. Okay, so the arrest piece of that video, that person who was arrested and now their case has been dismissed and sealed. So that person's identity implicates sealing. And that's the sort of thing we would redact for CCRB, right? Redact the person's face and voice and all that. But the rest of that video, the victim saying what happened, witnesses describing what happened, physical evidence that's been captured on video, like that is not sealed. That is actually, that is not sealed at all. And in fact, that may be crucial for an ongoing investigation. And so that is part of the challenge too, is that even if we had a way, which we don't, to to say, oh, this video, there's an arrest on this video where the arrest was subsequently sealed. It's not that the whole video is sealed. It's just one part. And then how to do that, we can do that on a one-off basis, right? CCRB is asking for, needs video. We're going to give them the video. Oh, there's a sealed arrest that's captured here. We make the necessary redactions. We get it to them. But doing that on a wholesale basis, like system-wide for 50 million videos, I'm not sure how we do that.
Has the department taken any steps to begin to segregate footage as required by relevant state statutes?
So just to be clear, it's not that the sealing statute, the core sealing statute, 16050, 16055, does not require, there's nothing in that statute that says, here's how you have to keep the sealed and unsealed records. Now, it does speak to use of those records, right? But the issue, right, the fact that there are sealed and unsealed records together is not like in and of itself the legal problem. The issue is, okay, like making sure that sealed records are not being used improperly. And they're two different things. And again, we at least right now do not have, like in the system that we have, in the volume of videos that we have, and the technology as it's set up, as the system is set up, we don't have a good way to just separate these things out. So it's a challenge for us.
Has the department consulted the cloud platform vendor Axion to determine how body-worn camera footage can be segregated based on whether an arrest has been sealed or if it is a juvenile court case?
So those are conversations that we are looking to have. But the issue is, in part, that at best, even if you could somehow overhaul the system, so let's say you overhaul the entire system, and maybe someday we can do that. Maybe someday we overhaul the entire system. But even if we did that, you still have the problem of videos where a portion is sealed, the rest is unsealed. I don't know that that's really an Axon issue or even a technology issue. It's just a fundamental challenge that we have. To be blunt, the sealing statute, I think it was passed somewhere, I think it was in the mid-1970s. If you look at the case law that talks about the application of the sealing statute and sealing, it really, by and large, is talking about a world of, a piece of paper in front of someone, a judge looking at a piece of paper. There even is, in some of the cases, some of the Court of Appeals cases, I think, there's talk about when you're looking at a particular thing and sealing, think about a document, you're doing this like case by case. That regime, the regime you have in the statute from the 70s, and that sort of, okay, we're assessing, sealing on like a case by case basis, on a document by document basis, that's fine, maybe, for a world, for like a paper world, where the case file is like in a folder that you have on your desk. In a world in which you have, like here, 50 million videos, I'm not sure we do. I'm just genuinely not sure.
So just so that I understand the answer correctly, you have not yet had conversations with Axion?
We have had some conversations with Axon about what it might be like to overhaul the system to do this. We have.
So,
but to be clear, it's like we've never done this before. Not only have we never done it before, I don't think any police department in the country has done this. The Axon system is not set up for that. Obviously, a nationwide system, as you know. So have we had some conversations? Yes. But like anything about doing this is speculative. It would take a tremendous amount of time.
Have they kind of given an idea in terms of time, cost estimates?
So I can say
copies
this:
of correspondence.
It would not be measured in days or weeks or months, right? We are talking, has to be measured in years, whether that's 1 year or 2 years or 3. I'm not sure, but again, not days or weeks or months. And again, even if we did that, even if we could wave a magic wand right now, I'm not sure it solves the problem, because you still have the situation where in various videos you have portions here and portions there that are sealed, and there's, I'm not aware of any means of, again, systematically sort of tagging, like this portion of the video, this, at this video at the 20-minute mark, this is sealed. And this video here at the 5-minute mark, this is sealed. And, here the sealing is for 2. I'm not sure what that looks like. I will say, as I said in the testimony, in terms of CCRB access, the solution is for CCRB to be able to have access to sealed records, right? Under the statute, the state statute, the state sealing statute, there are some narrow categories, statutory categories of who's allowed to access sealed records and for particular purposes, particular circumstances. CCRB is not on that list. CCRB is not allowed to see sealed records. CCRB is essentially like anybody else who's not on that very short list. And so, in terms of the issue of CCRB direct access, if the state statute changed, if CCRB could access sealed records legally, there would not be a legal problem with their having direct access to body-worn camera.
Is it possible, in terms of those conversations that you've had with Axon, that you would be able to share that information with us in terms of like the nature of the conversations, the guesstimate in terms of time, costs, estimates?
Yeah, I'm not the person to speak to that because it's the technology side, folks, and I want to emphasize, like, this is not a situation. There's not a situation where they've said, "Oh, if you want to do that, like, here's the project plan. Here's the time." It's not like that at all. This is nothing they've ever done before, because no other police department in the country, at least that uses Axon, has asked for anything ever remotely like this. And so this is all speculative. But, I think we will have future conversations with them about this. And, I think we're certainly, if we have more of a concrete sense of what this would look like, we want to be transparent with the city council about that. But again, we're not at a stage. It's not a situation where it's like, it's like, here's the proposal and here's the cost, and here's the timing. It's not like that. It's okay. Hey, this is an idea. Is this something that could be done? Possibly, potentially. Again, we're talking, a year or years, and something that's never even been scoped out before.
Is it correct to say that when body-worn camera footage is uploaded to the cloud on evidence.com, various types of metadata are added and can be later added to that video?
Right. So officers, and there are rules about this. Officers need to tag their video. There is tagging that officers do, and there are various tags for various purposes. Some related to discovery, some related to compliance. You can imagine why we want officers to tag videos in different ways. I do want to emphasize, though, that typically the officers are doing that tagging, or should be doing that tagging, in not real time, but shortly after the video is generated, right? And so at the end of tour, where the timing is, we're talking very shortly after the video is generated, the tagging is done. Given the sheer volume of video that is generated, right, an individual officer would not be able just to go back over that officer's body-worn camera video over some lengthy period of time and do tagging across the board. That, again, is sort of physically impossible. And again, the challenge with sealing is that it could happen at any time. There's no set time frame, and it could be a day or two later, could be a few weeks later, could be months or even years later. Right? So whatever we can say about officer tagging, that's really separate from sealing flags, which you couldn't ask an officer to tag body-worn camera for sealing. They wouldn't even know. So that I don't think would work. But is there metadata or is there tagging that officers do? Yes, absolutely.
Does this metadata for a video include the arrest number?
Yes. So for discovery purposes, arrests need to be tagged with the arrest number. Yes.
Okay, so if a single video captures what ends up being multiple arrests, are all associated arrest numbers included in the video's metadata?
So I think the answer is yes. I've never done the tagging myself, so I'm not exactly certain. It would make sense that if you have multiple arrest numbers, that those multiple arrests should all be associated with that video. But I would want to confirm that. It makes sense, and I would think so, but I would need to confirm.
Does the video metadata also include the docket numbers or numbers for cases associated with the footage?
I would assume I would have to check on that. I would assume it's just the arrest number. It is the tagging needs to be done to allow us to produce the materials in discovery for the case. So to the extent what you're getting at is a link between the arrest and the prosecution. Yes, the tagging, if done properly, allows that we push out the case to the DA's office. That material will sort of get swept up in what is sent over electronically to the DA's office. Again, how it works manually, I'm not certain, but yes, there is a means for linking up the arrest to the prosecution.
Does the body-worn camera cloud platform allow videos to be assigned certain types of tags? For example, if a video is related to a homicide or a Terry stop.
Yes, absolutely. Absolutely, yes.
Okay, are the videos related either of those things tagged as such?
Yeah, so the tagging, for example, the nature of the investigative encounter, level 1, level 2, level 3, level 4. Again, I don't know all the tags, but yes, this sort of tagging absolutely can be done.
Does evidence.com allow a group of videos to be assigned particular tags in bulk? In other words, would it be possible for a group of videos to be assigned a single new tag?
There is definitely a mechanism for bulk tagging. That exists. Now, how that works exactly, the nature of bulk tagging, I'm not certain. But yes, there is a mechanism for tagging multiple videos at the same time. That is doable.
Would it be possible for the NYPD to use a list of arrest numbers for sealed cases and arrest numbers for family court cases and assign those cases a specific tag?
Right. So this is the issue. That system, which changes on a daily basis, right, does not speak to the evidence.com system. Right. So yes, we have the OCA feed speaks to our system, and we're able to in real time make those flags in our system. We don't have a mechanism at present that connects OCA data to evidence.com videos. Right? So there's no that electronic connection, what I think is what you're getting at. Again, maybe someday we could do that. I think is it possible at some future date? Yes, I think it could be possible at some future date. But we're not there, we're not close. And again, even if you did that, you still have the problem of these videos actually aren't all sealed. I mean, that's the issue. And this is important, right? You can have a case, right? You can have, multiple individuals, carry out an armed robbery, a shooting, a murder. One of those individuals gets arrested. That case is dismissed for whatever reason. That person's arrest is sealed. But that criminal investigation is ongoing, right? That murder investigation is ongoing. That evidence, it's very, very important that evidence not be closed off to the detectives who are working on that case. That would be a terrible thing. And that I think is part of the challenge. There's a technological piece, Chair, which you're speaking to, but there's also this challenge of what do you do when certain sealed information is mixed in with material that is unsealed and that is important, critical at times for ongoing investigations. And important, for oversight. So like with CCRB, again, there's certain sealed material, there's other material CCRB needs to do its work, right? We have a way of accommodating that now. But that's crucial, right? In a world in which you said, okay, there's some sealed information on this video, and therefore the entire video seals completely, that would be terrible. It would be terrible both for investigations and fighting crime. It would also be terrible for oversight. So whatever ultimately happens, like that would be a huge problem.
If the NYPD received notification that a case is now sealed, can it work out a way to tag that video as sealed in the cloud platform?
Right. So this really goes to what we were just talking about. I think the on the technology part of this, right, the long-term answer would be, right, to sort of have some way for automating the process. Manually, I don't see how it would possibly work. But on an automated basis, right, in the same way that we do it for our own documents, someday we could do it for video as well. Again, it only solves the first part of the problem. That solves the flagging videos part. The question is then what do you do when you have both sealed and unsealed information within the video? But yeah, I think, again, on a long-term basis, potentially we could do that. We're not anywhere close, but someday I think we could.
Has the NYPD contacted the cloud platform vendor to do this with its own body-worn camera videos?
Well, this is what we were talking about earlier. I mean, we have had some conversation with them about this, and the message back, frankly, has been that we can talk about it, and it's not outside the realm of possibility, but it's something that's never happened before. It's never been done. The kind of thing we'd have to sort of plan it out. That's figuring out how much it would cost and the time frame and the scope of it. Obviously it would be a major undertaking. We're talking about also like a massive platform. We would not want to do this. If we're going to do it, we have to make sure we do it right. It's very important that if we do this, it be done the right way. So that's the kind of thing we could rush into. I think that would be irresponsible. But it's something we definitely could explore, though we would need to figure out, if we go down that path, we need to have a solution to the second part of the problem too. Like what we don't want to do, or if you do this whole overhaul, at whatever time and cost it is, and then you still have the second problem of, okay, now we've figured out that there's this universe of videos where some things are sealed and some things are not. What do we do with this? I think we need to figure out what that answer is, and I'm genuinely not sure.
Does the body-worn camera platform allow one to create users with different levels of permissions?
Yes, it does.
And what type of restrictions can be applied to the user level or at the user levels?
In terms of the details of this, I'm sort of the wrong person to answer those questions. But I can say there definitely are permission levels. It can be set. In terms of how granular it is, I'm not sure. But certainly there are different permission levels within the department.
Is it possible, for instance, to create a user permission that is prohibited from accessing a video that has like certain tags, for example, like sealed?
Right. So if we got to a place, right, someday where you had, okay, all these videos are tagged as sealed, could we then shut off access to those videos? Yes. But again, the problem is, if you're a detective investigating a case, say a murder investigation, those videos may actually be crucial evidence in your ongoing investigation. And the stuff is not sealed. It's of someone a witness describing what that witness saw. The witness saw a murder. That's caught on video. That video could be on the same video as an arrest. That could happen in any number of crimes. It could happen a robbery, a shooting, whatever. And I really do want to emphasize, even in a world, if you shut off access to sealed records entirely, to those sealed videos, where the sort of key evidence and sealed material is mixed in, well, what are we doing exactly? Are we saying that the detectives can't investigate that case? Are we saying that CCRB can't access that material for its work? Right? Again, for both investigative and oversight purposes, there are things on these videos that are critically important.
Gotcha. So I will pass it now to my colleagues, starting with Councilmember Caban.
Thank you. I left you all by yourself today.
I am.
Okay, I'm going to go back to some of the chair's initial questions. I just want to get a little bit more granular with the details. You testified that NYPD learns that a criminal proceeding has been sealed pursuant to the sealing statutes, that you rely on OCA, and OCA sends you a list. That's correct?
It's a feed. I think, again, I'm not the tech side person. I think it's in some sort of file, whether it's Excel or otherwise. But
So
yes.
I can make it super easy. I'm actually holding an affirmation of the deputy inspector of the Information Technology Bureau,
Inspector Amasia,
who
yes.
confirms that yes, they rely on OCA. You get sent a list, and that list or that feed does come every single day, and that's according to the affirmation.
Yeah.
Okay. So one answer I don't think we got was what specifically, like, what information does NYPD receive about the case, about a case when it becomes sealed? Does it, like, do you receive the arrest number or the docket number?
I know that we receive enough information to allow it to flow into our system. So I'm not the one involved in the
So
feed,
can you get back to this committee
Sure.
on whether you receive specifically the arrest number or the docket number?
Sure, we'll do.
Great, thank you. Okay. And you said that you testified that the NYPD learns that a case has been sealed, the associated records sealed in the NYPD databases, like that process is nearly instantaneous, correct? Those were your words.
I think what I actually said was it happens quickly. It may not be actually
Yeah.
instantaneous,
Well,
but it happens quickly.
Okay, great, thank you. And I'm going to move away from that for a second. I just want to talk about the purpose, to frame this, the purpose of sealing, the sealing statutes, right? Like, and this is important for the record. We seal to prevent undue prejudice against the accused from knowledge of inadmissible or impermissible information, right? Because it goes back to our constitutional rights towards the presumption of innocence, and also the constitutional right that the state bears the burden of proving guilt beyond a reasonable doubt, which is a really high burden. So, like, using that framework, I'm going to give an example. I'm in arraignments in night court. So obviously, you all very much well know by now that I was a public defender, and I'm representing a client, and the prosecutor gives a bail argument, and it's talking about these prior arrests, these prior things, and then all of a sudden the judge goes, "Stop right there, counselor. Where are you seeing that particular arrest or incident? Because it's not on my screen. Is that sealed?" And every once in a while, that assistant prosecutor gets caught using sealed information, and that's a huge no-no. Again, because of that constitutional right and the need to prevent that undue prejudice that's outlined in our laws. So, knowing how important that right is, I just am not convinced that evolving technology is an excuse to water down that right, about protecting that fundamental right. And it's imperative, right? And so I know that you have testified that it is burdensome. It's too burdensome to catch up, to be able to do this on a case-by-case basis. And in fact, I have in front of me another case out of the Supreme Court of State of New York before Judge Frank, who I used to appear in front of when he was a new judge. But the Bronx defenders are the plaintiffs. The city law department is representing the city, and they essentially say the same thing, that being able to seal these things are unduly burdensome. But we don't violate people's constitutional rights because it's hard, right? The burden is on the state. It remains on the state. And that's just a reality we have to live with. And the state has to decide what technologies they can and can't use to maintain the protection of our constitutional rights. So that's just like a statement I want to make about the record. But I also want to address your testimony, your initial testimony, where you said that the Intro 1451 would violate state law, and that you're currently in compliance with the law, and this would force you in conflict with state law, correct?
I mean, you have my testimony. I read the document.
Okay, so yes, so then that is correct.
Well, I'm not sure you quoted exactly right, but you have my testimony.
This law would put the NYPD in a bad position because it conflicts with existing state law.
My testimony is that we cannot give CCRB access to sealed records without a waiver or redactions, and that direct access would do that.
Would be in violation of the state law.
Yes.
So I may I have another minute or two to make my point. So I guess my understanding is that, and you've testified to this with the complications around family court, you already are in violation of the state law. Like, do you think that NYPD has a legal obligation to segregate sealed and unsealed records, and whether or not you're complying with that legal obligation, because you're storing them already, and it's currently in violation because Court Act 381.3 requires keeping juvenile and adult records separate. So OIG says that the NYPD's commingling violates that state law. So you're already in violation because of the complicated commingling that's happening in family court.
So there's actually two separate issues, right? One is a sealing issue, and one is family court regarding keeping adult and juvenile records separate and apart from sealing. I think they're actually two different issues. But I hear what you're saying, and I think I've said multiple times that we have work to do. There's no question about that. I do think, wherever else one can say, I stand by this. I don't think the city should pass a law that would compel us to do something that violates state law. I do stand by that.
But we are acknowledging that you're already violating state law with the commingling of these materials in family court. And I guess my point is this: if that's the concern, to give the CCRB direct access, NYPD has to comply with the sealing statutes by separating the sealed and unsealed body-worn camera footage. And as we've seen in the testimony, you can do it by tagging footage as sealed or unsealed based on the arrest number in evidence.com, and then giving the CCRB permissions to access everything except for the footage that's tagged as sealed. And so the affidavit that I referenced earlier is relevant because it shows that NYPD receives the case sealing information from OCA every single day, as you testified as well. So you can use that daily information to ensure the footage is tagged as sealed. I get that that's like a big project, but again, when we are weighing efficiency, where we're putting our resources, updating technology, or our fundamental constitutional rights, I think our fundamental constitutional rights have to win out. My last question that I'll leave with you here is, one point and one last question is, you testified in your initial testimony that the NYPD and the CCRB have been working collaboratively and successfully for years. I would say that I've been here 4 years. An oversight hearing where CCRB comes up and says, please help us because the NYPD isn't collaborating, isn't giving us the information we want in a timely manner, whether it's the Post Act, whether it's other reporting bills, whether it's the discipline cases. So it sounds nice on paper, but that's just not the testimony that we receive every single oversight hearing when we have CCRB in the mix. So my question is, it would be helpful to know in the context of the body-worn camera area, what policies or procedures for determining when body-worn camera footage seals, and if you have like set policies or procedures for segregating sealed from unsealed footage.
Sorry, I'm not trying to understand the question. Can you repeat the question? What's the question?
If the NYPD has official policies or procedures for determining when body-worn camera footage seals, and if you have any policies or procedures for segregating sealed body-worn camera footage from unsealed footage. And the reason why I'm also asking this is because in that case with the Bronx defenders, and Judge Frank rightly questions this, the city's lawyer says that, well, they're not automatically sealing them. And again, they say that it would be prohibitive to try to do this case-by-case thing because it's just hard. But essentially, if it's not sealed when it should be, the city's lawyer is saying, well, if we want to use it for investigatory purposes, we'll go to the court and ask for permission to do that. We're just going to, we're going to do it. We don't have to be told. We're not going to look, even though we shouldn't look at it. We know we shouldn't look at it. We should get the permission from the court. We can access it, but we're doing the right thing. We're not accessing it. We're going to go to court first. The judge rightfully says, if we can access it, I I don't think that that's actually what's going to happen. I think people are just going to go access it and not use that discretion or that discipline and come to the court and ask for it. And that's why it's important that it's sealed.
Well, I mean, we do go and get unsealing orders in connection with various investigations. That happens.
Right, but if
pursuant to
it's
the statute,
but,
as you know.
But if we're talking about body-worn camera footage that currently is not sealed but should be, right? The position is that you can access it, right? It's like what I talked about, that arraignment example where, like, you're not supposed to look at something, but you're looking at it, right? And so I don't know that the city, certainly this oversight body, would feel comfortable with that body-worn camera footage being available, although the NYPD or the officer might know, hey, technically it's supposed to be sealed. It's not physically sealed because too hard for us to do it, but it should be sealed. So I'm going to go to the judge and ask if I can look at this thing. And, like, we're supposed to believe that that's what's happening.
So a few
And
points.
the judge actually puts it on the record that he that's his concern, because he doesn't really think that that's what would happen.
So a few points. One, again, as I testified earlier.
Before you answer, I just want to remind us that we will have a second round of questioning.
That's it. That's my final.
Just to adjust a few points just from now, though. One, again, we have the system that we have. We have the technological constraints that we have as the system presently exists. I think I described earlier kind of the challenges in order to address both the technological piece of this and this not unusual, but this challenge of the intermixing of sealed and unsealed within a video. I do want to make one point, 2 points. One, again, this issue about the commingling in and of itself, it's not really a sealing issue. I don't think the sealing statutes actually speak to that. The separate issue in family court about adult and juvenile records. But with regard to our cooperation with CCRB and whether we are getting them materials, in a timely fashion, whether we are working collaboratively with them, I think certainly for the past, let's say 2.5 years, that is 100% true. I stand by that. CCRB is going to be testifying after me or later. Please ask them. Ask them if they agree or if they disagree. And they'll say what they'll say, but I stand by that.
Okay.
All right, we'll now hear from Councilmember Holden.
Thank you, Chair, and thank you, Deputy Commissioner, again for your patience and very complete answers. Just want to talk about, now you're Deputy Commissioner of Legal Matters. So
Yes.
You know all things legal, at least you.
Not all things,
Well,
no.
most things legal, let's put it that way. Nobody knows everything. But your testimony says that it's obviously a very complicated issue, releasing body cam video, right? I mean, it's complicated on legal matters.
Yes.
So tell me the consequences of violating state law. What can happen?
So I would say there are two pieces to that. One, before I answer your question, we should never be in a situation in which we are, like the city council should not be directing us to do something where we know this will violate state law. There are times when there are constraints and there are problems and there are issues, but my point is, in a world in which everyone knows, like, giving CCRB sealed records without redaction, without a waiver, would violate state law. And then to sort of deliberately say, like, we are going to do that, put aside consequences for a second, I think it just goes to sort of a fundamental question about the rule of law and how we think about that and the need to comply with the law as best we possibly can. In terms of consequences, so it depends. And, if you look at the case law, in situations in which sealed records are used in a proceeding or used in an investigation, and to Council Member Caban's point, this is incredibly serious thing. There are some cases where a court has said, well, for various reasons, yes, it was an error, but we're not going to, dismiss the case. There are other situations in which, for example, certain disciplinary proceedings in other contexts have been dismissed, where the entire sort of case has fallen apart because it emerged that some crucial piece of evidence was sealed. And again, the analysis is a little bit complicated. It's not, I can't say, oh, if you use sealed records, automatically the case gets dismissed. That's not how it is. A court will look at multiple considerations, but the fact that whether it's in a criminal case or in a disciplinary proceeding, if the prosecutor, and that would include CCRB, is using sealed records, and then it emerges, wait a minute, you're relying on sealed records improperly, that puts the case in jeopardy. And then on top of that, you worry about liability issues.
Well, that's what I'm
You know,
curious
so that
about.
too, but
what
I
could
think
this cost the city in the way of let's say, somebody's rights, a defendant's rights were violated?
like it's hard to answer that question. And so I think there is a liability issue, but I think I just want to emphasize before you even get to that, we want to do our very best to follow the law. We should not deliberately be doing something that violates state law.
Which I'm surprised. I've been on the council now almost 8 years. I've never seen a case, or at least a bill like this, that, because the council legislative division would always defer the state law and not try to violate it. This is the first time I'm hearing something egregious like this. It's an obvious one. The bill even mentions state law.
Yeah.
But the way you describe the video, the body-worn video being released and redacted many times, this doesn't allow you to do that, really.
No, so right, the way we do it now is if CCRB needs records, we make the necessary redactions, they get the video, and they do what they need to do. In a world in which you have direct access, right, it's a different regime. It's not a redaction regime, it's CCRB going into any of these videos, including videos where there's sealed material. And again, they as a matter of state law, that's just the problem. And then, frankly, if they ended up relying on sealed materials, in let's say in an APU case, for example, where they're the prosecutor, that could put the case in jeopardy.
Right.
It's not good for anybody.
Yeah. So just one other, I'm running out of time. So just on intro 1460, you described Citywide 1. Could you elaborate on that?
Yes. So we have various there are various radio channels that we use. Some of them are what we call zone, like the zone channels, which are, Chair, may I just finish up the?
I think I'm okay.
Okay.
I mean, consider the previous
Got
question.
it. So you have the zones, which are typically like 2 precincts. Every once in a while it's 3, but typically 2 precincts. You have the zones. Then you have borough channels, and then you have citywide channels. Those are broadcast citywide across all 5 boroughs. And what I was getting at before is for any critical incident, and I listed some of them, there's a longer list. For any critical incident, that'll get broadcast over multiple channels, right? It'll typically get broadcast over the local zone channel. It'll get broadcast over Citywide 1, which again is unencrypted. It may, depending on the radio code, if it requires special operations, for example, if we're going to have to send ESU in, it's going to go, to special operations channel, and ESU is going to make plans to, by hypothesis, addressing, some very dangerous situation. The way it works is you have these radio codes. So the 911 call comes in, the person, the 911 call taker hears the description, and then they enter that in the system. There's a radio code associated with that. And then depending on the radio code, that automatically goes to various radio channels, right? And so there's a whole set of radio codes that automatically will get sent to the dispatcher for Citywide 1, and then automatically gets sent out over Citywide 1. So anyone, anywhere in the city can hear it, if that answers your question.
Well, again, the codes are, right now we have them for precincts, that we can tap into that. That's going to be...
No. So when I say radio codes, what I mean is the nature of, like a 1013, for example.
Right.
Officer needs assistance.
Oh, you're talking about the
So a
results,
1013,
right?
you can imagine that going over multiple channels,
Right.
obviously. but one channel that will go over automatically is Citywide One, the unencrypted channel.
Right.
And the idea is that all these major incidents or types of crime, a variety of matters that are of public interest, and the kinds of things that I totally understand reporters want to go cover in real time. That's all it is now and will be.
But the bad guys won't get the important information that they could.
Right. So, and I want to be crystal clear about this. To the extent you have an active shooter. Okay. So the fact there's an active shooter will go out over Citywide One, unencrypted. Special Operations is doing what it's doing. That will be encrypted, as it should be. So it's not that all information about what we're doing in response to a particular situation will be over Citywide One, but the fact that this is happening. Hey, there's been a shooting at this location. There's a robbery in progress at this location. There's been an explosion at this location. All that sort of thing, the kinds of things that reporters are going to want to go cover, unencrypted, and we're prepared to commit to that.
Thank you, Chair.
You're welcome. We'll hear now from Councilmember Brewer.
Thank you very much. And I heard earlier, because I could listen, because it's not encrypted, this hearing, just so you know. That's a joke. I want to follow up on Councilmember Holden's question. So thanks to you, I do understand what Citywide One is. But my question would be things like local journalists. They want to know, like, what about the helicopter above that's making noise for 1 hour? That doesn't seem to be a crime, but it's something that is of interest. I don't know if that would be covered. Armed hijacking inside a neighborhood parking garage, I suppose that would be covered as an example. But the photojournalist is also an issue because he or she wants the picture. You can't get the picture afterwards. So I guess my question is, first of all, thank you for even considering the issue of encryption and what is or isn't, and I appreciate the opportunity to keep working on this and coming up with something that we all can agree on. But I guess I wanted to know just a little bit more about some of these local issues. I talked about store theft when we met. That would not be covered. But are there some other issues that you think could be in Citywide One that may not be now, that would not be DV, that would not be sensitive, that would not be something, because the local folks are interested, I hate to say the word quality of life, but the helicopter above is a quality of life issue.
Right. Though the helicopter above, I mean, it's a little hard to do this in the abstract. To the extent the helicopter above is if we have a helicopter, it's probably because there's actually been some large scale.
And they want to know that, so that would be covered?
Right. So any large scale or unusual incident is on Citywide One. An unusual incident for us, I mean, I guess it's actually the colloquial meaning. Anything that's not sort of your run of the mill radio codes will go out over Citywide One.
What about fires? How does that? I know it's a different system. Does fires get covered this, or that would be?
Oh, that's
completely different?
FDNY. That I don't know.
And road crashes. That's the other thing that people are interested in. This is what it's not quality of life, but it sort of borders on that topic.
Right. So road, a vehicle crash would not go out over Citywide One.
Okay.
I do think
These local
do
people
fatal
like
crashes.
that stuff. I don't know what that is. Go ahead. I don't know what that is.
Sorry. You mentioned I think it was an armed
In a garage. These were examples given to me. An armed robbery in a garage. I assume that would be covered.
Any robbery in progress, armed or not, goes out over Citywide One.
Okay.
It is a tremendous number of events, and it is a wide range of coverage. Now, it's not everything. I do think, and I really do want to emphasize this again, when you get, there is a universe of calls that come in that go over the radio that really do implicate privacy issues. We've been talking more about the operational sensitivity, but there are real privacy concerns.
Right. I understand that.
And I think that's really important. And I think that a challenge we have is, and I think different than other places, is the sheer volume.
Correct.
And I just think whatever ultimately the answer is precisely, I think it has to account for these various interests and be something that is administratively feasible and that we can do, in a rigorous way without generating, significant errors. Because we want to make sure the cops are safe, public safety, privacy concerns, but consistent with that, our view is that Citywide One really does a tremendous amount to sort of give journalists and photojournalists kind of what they need.
Now, there's a state bill that has not been signed by the governor. Does that include what we're talking about? Is it broader? Is it less? What are you doing about that state bill?
So that state bill is before the governor. The bills, they overlap substantially. They're not, I don't think they're identical. They overlap substantially. I would have to go back and look to really sort of say precisely where the differences are. The general framework of the state bill and your bill are the same. There are, I think, some wording changes and maybe some substantive differences, but the basic structure is the same.
So are you supported the state bill or not, or have you testified?
No. So we do not support the state bill, really for the reasons articulated
Right. I just want to be sure that you're not supporting them and not us.
No.
Trying to get clear here.
No. And look, we'll see if that bill becomes law. We just don't know.
Okay. On technology, how is it different, I guess, getting moving on encryption now? Is there a difference in the technology? Is it the same? Have you updated? What's the story in terms of?
So yeah, we've upgraded. There's been a massive upgrade in the radios. It's been phased in over time. There's still ongoing encryption that is happening through the end of this year and the first quarter of next year. Almost all of the zones are encrypted. Most, but not all of the borough channels are encrypted. Look, one of the issues is that our radios, and I'm definitely not the expert on this, but our radios were getting old, like really, really old.
Right.
There definitely was a need to upgrade. We want to be at the cutting edge of technology, not behind. Encryption has become the national standard, I think, for the reasons that I tried to articulate. So there very much was a need for that upgrade and for the encryption. And then, what we're working to figure out is, okay, how do we, having done that, accommodate sort of the concerns principally of reporters and journalists.
And then, of course, there's always going to be the request for journalists, obviously for people like the Central Park Medical Unit, to have special consideration, because I don't, that has come up. Is that something that you would consider for beyond the Citywide One, or is that not something that is on your list of support?
So those
are the people who are asking. Now, maybe Citywide One will be enough for these individuals. But.
Right. So there's a whole separate piece to this of, okay, in whatever we have sort of we have encrypted channels, we have Citywide One unencrypted. We have some unencrypted channels that are also remaining unencrypted for a different purpose, and that is to communicate with various outside entities that don't have access to our system.
Okay.
So, one thing that the department has been working on under, as per Commissioner Tisch's directive is
like her.
Like we need to have a system if whatever the outside entity is, whether it's an emergency service, whoever it may be, if they are requesting access to our channels, okay, there needs to be a system. There's an application, there's a process. You need to explain what they're looking for, their needs, technological side, practical side, a committee to review these applications. And there are multiple answers, right? There's a range of, you can have access to our channels. You can have access to certain encrypted channels. One possibility is, look, you can have access. We will set it up. We'll make it work for you to have access to these channels that they're not encrypted, but that are monitored, and you can communicate with us back and forth over the unencrypted channels. And then in some cases, the answer could be, hey, listen, given what you've described, you don't need access to our channels at all.
Got it.
But I do want to emphasize there really is in place now, in a way that maybe was not the case before, really a very rigorous process for reviewing these requests.
And people do use that process? People are using that process?
Yes, I should say it's really very much ongoing. So there's something that's happening now, and frankly, reviewing kind of the department is looking at, all right, so who historically has gotten access?
Okay.
Who has access now? Does
Okay.
that make sense?
Okay.
Frankly, even if you had access before, we're going to go through this process, fill out the form.
Okay.
Why do you have access? And the answer might be, that makes total sense. Or the answer might be like, that doesn't make so much sense. So that process is ongoing, and that is, very much case by case, entity by entity. And I think what we're doing makes a lot of sense.
All right, so we're looking forward to working on this bill with you, and I thank you very much. Just one last comment about paperwork. I assume that the person applying from either the medical unit or the journalist is doing it online, but the person going to the, getting the bicycle crash paper at the precinct is still doing it on paper. I'm just saying, and we just want to work on that with you.
You mean on the FOIL request?
No, just going to get the information so you can go to the insurance company.
Oh.
Precinct. And then you can't get the paper. So I have to call for the paper. I'm really good at calling for that piece of paper, but I would love to do that online. Different topic, but
Understood.
let's work on paper.
Understood.
Thank you.
I think that might be it for you. Thank you. Thank you for your
Okay.
testimony.
Thank you very much. Thank you. Thank you.
It was very funny. Whenever you wanted money, it's a volume kind of thing. Like he said, you can ask this area. So I'm curious what they ask.
They're going to ask you if we are working together collaboratively and successfully to get you the materials you need. I'll talk to you later. Thank you.
It's about 20.
We'll now open up the next part of the hearing for testimony from the CCRB.
Good morning. We'll be having testimony from CCRB Executive Director Jonathan Darsh. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee and respond honestly to council members' questions?
Yes, I do.
Thank you. You may begin your testimony.
Thank you. Good morning. My name is Jonathan Darsh, and I use he, him pronouns. I'm the Executive Director of the New York City Civilian Complaint Review Board, testifying here today as our agency is currently without a chair or interim chair. I am grateful to have the opportunity to testify here and address this council. Specifically, I've been asked to speak about Intro 1451, direct access to body-worn camera footage. I want to begin by emphasizing that this issue is extremely important to the agency and to civilian oversight of police more broadly. body-worn camera footage is a significant component of our investigative process. In both 2023 and 2024, the CCRB received over 6,000 hours of body-worn camera footage, and in 2025, we're on pace to match that mark. That footage has come in via thousands of individual requests, 2,076 so far in 2025. It's a lot of work, but it matters. Body-worn camera footage allows us to close cases on the merits at a higher rate. In 2025, to date, we've been able to render a determination in 80.75% of complaints where there is body-worn camera footage available to view. When we do not have this footage, that percentage drops to 53.71%. The CCRB has long advocated for the agency to have direct access to body-worn camera footage, including during our most recent testimony to this committee in September. The most important benefit of direct access is that it would strengthen the democratic legitimacy of our investigative process. The CCRB is a civilian-led police oversight agency, the largest in the country. When New Yorkers come to us with a complaint regarding potential NYPD misconduct, they know that we are civilians just like them and that we are not beholden to the NYPD. That matters. That civilian-led independence was baked into our identity by Mayor David Dinkins and this council when it voted to restructure our agency in 1993. Since then, we've been guided by the principles of independence and impartiality. But when our investigators request body-worn camera footage from the NYPD, it is procedurally necessary for the NYPD to enter the investigative process. This tests our independence. The NYPD must review the raw footage and make a decision on how best to fulfill the CCRB investigators' request. In some instances, the NYPD may be unable to find footage matching a particular date, time, or location. Even when these decisions are correct or made in good faith, it undermines the CCRB's independence to rely on the NYPD to make those decisions. Having direct access to body-worn camera footage eliminates this disconnect. It means that, from beginning to end, the CCRB is managing its own investigative procedures. It means that all decisions made in an investigation are being made by civilians, not the NYPD. This matters. This bill is a positive step, and the CCRB has been clear about the profound impact direct access to body-worn camera footage would have on our work. We appreciate this council's willingness to act on the issue. While the CCRB is excited about the prospect of obtaining direct access to body-worn camera footage, I want to note that to fully realize the benefits of the bill, we will require resources and an exemption from the New York State's sealing statutes. But with this bill, the council is showing a commitment to the ideals of civilian oversight, and it is doing so at a moment when civilian oversight itself is in desperate need of this type of public support. This matters. I thank you for that commitment, and I look forward to answering your questions.
Thank you for your testimony. So I want to ask about access workflows and current delays that you all may be experiencing. How long does it currently take the CCRB to obtain body-worn camera footage from the NYPD after making a request?
On average, eight days.
Of all CCRB investigations that request body-worn camera footage, how many experience delays, and what is the average duration of those delays?
So the average time to receive a response is 8 days. As long as the CCRB has been requesting body-worn camera footage, there are approximately 1,000 complaints that involved footage where we needed redactions. And those complaints, it can take much longer than 8 days, sometime in excess of 100 days or 200 days to get the redacted materials. But again, that's a small number of complaints compared to the larger universe that we have. There are generally, you had mentioned workflow. Do you mind if I expand upon that a little? So when we make a request, our investigator sends it to our document request specialist. The document request specialist sends the request to NYPD Legal. NYPD Legal has a staff member assigned to them that conducts the search. And if NYPD Legal determines that there are sealed materials in the footage, then they ask us for a waiver. Now, we, as often as possible, get waivers proactively from people when they file complaints with us. But the nature of body-worn camera footage and the sealing statutes makes that difficult, because one person may file a complaint with us, but body-worn camera footage may have multiple people in it who have cases that are involved or have reason for that footage to be sealed. It's not just the Criminal Procedure Law and the Family Court Act. It's also Civil Rights Law 50B, which protects victims of sexual assault. And so if you have people in the picture who might not have been arrested, so you don't even know who they are, it becomes difficult to ascertain how to get a waiver from them. So the next step is then to ask the department to redact the footage. And it's interesting because this didn't start from the NYPD. This process started because of the law department actually made a determination that they felt body-worn camera footage was akin to an arrest record. I actually think that, and there have been courts that have gone both ways. I think body-worn camera footage, the city's position should be that body-worn camera footage is like a 911 call. I understand that there are privacy advocates who are against that, but I think that these materials aren't sealed. As Deputy Commissioner Gerber said, when the sealing statutes were enacted back in the 1970s, they were envisioned as a document related to a particular case, and then that document would be sealed. We have somehow let that expand, that concept expand, so now that there are certain videos where a portion may be sealed and a portion might not be sealed, it's just not what the statutes were intended to regulate. And I think that we would be better off to view these things as akin to a 911 call, and that they are not sealed at all under the sealing statutes. But as long as we are going to view them as sealed, then the CCRB needs to be exempt from the sealing statutes.
Understood. What specific internal bottlenecks does the CCRB face under the current request-based system?
So our process is that we make a request to the department, and then the department finds the data and sends it back to us. There are two delays in that process. First, there are some times where the CCRB makes a request and the department is unable to find responsive body-worn camera footage from the nature of our request. Sometimes as the investigation goes on and we get more information, we are able to narrow the request so that the department is able to find the footage. Sometimes we interview an officer and the officer comes and says, no, I had my body-worn camera on that day. And then we're able to go back and give the department more information, and they will respond with the body-worn camera footage. The other bottleneck is when we are unable to get waivers and there needs to be redactions before the CCRB can get access to the records.
Can the CCRB provide examples of where late footage materially impacted the outcome or timeliness of an investigation?
So it's difficult to choose one case because I'll go back and see if we can find one. that 8 days is an average. So there are some that come back sooner and some that take longer. And part of the problem is that a delay in one case spirals to affect many cases. And so it is tough to look at things in a vacuum like that because we have so many cases and relatively few staff, it becomes problematic very quickly.
I'm going to go to operational capacity under direct access. If direct access is granted, how will the CCRB screen and search footage?
So our investigators would use the Axon system. That's name is escaping me right now. I apologize, even though Deputy Commissioner Gerber mentioned it 500 times. Evidence.com. Evidence.com. In the same way that the department uses evidence.com. And we would be able to, the reason it would reduce the bureaucratic obstacles to fast investigations is that the investigator who has the case and knows the most about the incident of the people involved can just go and look for the footage, as opposed to having to fill out a request, send it to the department, have the department look, and then the department send it back. With regard to how the CCRB would use the information, we have a legal review and a FOIL review that makes sure that the evidence we release to the public does not contain sealed or private information. And we would continue to do that.
Will the CCRB require additional staff, training, or IT upgrades to responsibly manage direct access?
So, with regard to the IT issue, we think we would be able to use the NYPD's contract with Axon to get licenses for our staff to be able to use evidence.com. So I don't think it'll have a IT impact. There is a impact on the amount of footage we have, but that is there whether we're getting it from NYPD or getting it directly.
I want to move into
On the staffing side, we think there's a minimum of an additional 25 investigators, and some of our estimates are as high as 50, but we need to, that is on top of the request that we made last year for 140 more people that was unmet. So like right now, the CCRB is closing, we're on pace to close 2,000 cases that are within our jurisdiction without an investigation, because there was just no way for us with our current level of staffing to investigate those complaints in a timely way. Based on what the council did by giving us 20 more people and the ability to pay them in the last budget, we have been hiring up, trying to get to that headcount of 100 and that additional headcount that you provided us, so that we can take some of the categories of complaints that are on our list of allegations that we do not investigate, even though they're in our jurisdiction. But we are still below the allocated headcount. To add this additional work, it is going to be significant.
I want to move to legal and statutory compliance. How does the CCRB currently handle footage that later becomes sealed or is part of a sealed proceeding? And does the CCRB have protocols in place for the destruction or restriction of records when cases are sealed post-investigations?
So we have a review process before any information is released to the public, and we make sure that our systems are secure so that information is not leaked. We have as Deputy Commissioner Gerber described, it is tough to know what footage in a body-worn camera footage, what portion of body-worn camera footage is sealed or unsealed without going and reviewing it. And that is because it is not as simple as saying individual number one was arrested, that arrest is sealed, so this body-worn camera footage and that body-worn camera footage should also be sealed. You're dealing with cases where there may be people in the background who are not directly connected to an incident that also would cause the case to be sealed if you were using the law department's current definition of body-worn camera footage as an arrest record.
This is about vendors and maybe some technical questions. Has the CCRB consulted with Axion or another vendor regarding technical requirements for direct access?
Yes. The CCRB, there would not be a technical problem to CCRB obtaining direct access. There would be the issues of sealed records and the issue of the additional investigative burden being transferred from NYPD to CCRB. But there is nothing inherently different from a CCRB investigator having access to evidence.com or an NYPD NYPD employee having direct access.
Gotcha. Can you tell us lastly about lastly about the Delron Small Officer Wayne Isaac case?
So Officer Isaacs shot Delron Small on July 14th, 2016. In 2017, the New York State Attorney General's office tried Police Officer Isaacs for homicide, but Police Officer Isaacs was acquitted. The CCRB was informed by a prosecutor on the criminal case that Police Officer Isaacs claimed at trial he was motivated to shoot Mr. Small because Police Officer Isaacs did not want Mr. Small to take his department weapon. In May 2018, the family filed a complaint with the CCRB. In July 2020, the CCRB substantiated misconduct against Police Officer Isaacs. In October 2020, the CCRB, through its Administrative Prosecution Unit, filed charges against Police Officer Isaacs with the police department. Later that month, Police Commissioner Shea declined to retain the prosecution, and the department served charges on Police Officer Isaacs. In 2021, the city settled a lawsuit by Mr. Small's family. During the litigation, Police Officer Isaacs demanded the city insure him because he was acting within the scope of his employment as a police officer when he killed Mr. Small. And then a federal judge ruled in favor of Police Officer Isaacs, so the city had to pay the vast majority of the money that went to Mr. Small's family. In April 2022, Police Commissioner Sewell declined a request from Police Officer Isaacs to retain the prosecution and dismiss the charges against him. In September, Police Commissioner Tisch declined a request from Police Officer Isaacs to retain the prosecution and dismiss the charges against him. Courts have held that the CCRB, if it uses a reasonable process and follows CAPA, gets to define its jurisdiction within the charter. The police commissioner gets to decide who represents the department in disciplinary cases. 2 weeks after a third police commissioner decided to let the CCRB try the disciplinary case against police officer Isaacs, Deputy Commissioner Maldonado dismissed the case and took it off the trial calendar. She did that 2 weeks after a third police commissioner instructed that the CCRB try police officer Isaacs. She did that despite the fact that during the criminal trial, Isaacs claimed he shot Delron Small to keep Mr. Small from taking his service weapon, and she did that despite the fact that Isaacs demanded the city pay the family because he killed Mr. Small in the course of his duty as a police officer. I've been familiar with Commissioner Tisch since she was a deputy commissioner at the department. I have a lot of respect for Commissioner Tisch and her team. I'm confident she will reject this deeply flawed recommendation in order the trial to go forward.
Thank you. We'll now hear from Councilmember Ariola.
Thank you so much for coming in to testify today. I want to go back to our public advocate's part of his testimony. He says, in addition to giving CCRB direct access to evidence, we must empower CCRB to enact its own disciplinary recommendations and ensure they have funding and staff necessary to complete all investigations for misconduct under their jurisdiction. So, in further clarification of this bill, I would just like to know that if the CCRB has total access to police-worn body cameras where they can set up a team to review the body camera footage, as a result, could they, if it goes over the time allowable, could the CCRB still generate their own complaint against police officers without any complaint being lodged?
Councilmember Ariola, I think I understand the question, but if you could clarify the portion about is the concern that the CCRB will
Correct.
or is it a timing issue? Which is
so
the
if
concern?
it goes over the statute of limitations time, when you have the opportunity to review their body-worn footage from their camera, can the CCRB still lodge a complaint on their own against that officer
So
under this bill?
So I just want to say, before I give the short answer to your question, I'm going to reverse this. Normally I do short and then long.
Okay.
But the long part first is the CCRB does not have enough resources right now to currently investigate all of the complaints we get. The CCRB has had the power since the last charter revision and the rules that were passed to implement the charter revision to initiate its own complaints. We have not done so in a single case because we are already drowning with the number of complaints we are getting and the resources we have to investigate them. So I understand your concern, and the short answer is yes, we could, but A, we just don't have the capacity to do that, and B, we are not in the habit of, it is unlikely that we would find misconduct that was in body-worn camera footage that had not been explained, had not been discovered previously, that was exempt from the statute of limitations. So I understand the concern. It is theoretically possible under the language of this bill, but it is just not a realistic concern.
And so, just in addition, from your testimony, what I'm really hearing is that it's not a matter of not getting the information in a timely fashion or it being 8 days late. What it really is that you don't have the funding or the staffing to get through the maybe thousands of camera footage, thousands of footage, hours of footage that you need to get through in order to make a determination within the statute of limitations because you lack the staffing and funding to do so.
That is all true, but I also think there is a value in the independent nature of the agency saying that we do not have to go through the department to get access to our evidence. And I understand it is inevitable that there is some interaction between the department and the CCRB. There has to be. But and I think there are going to be times where a CCRB investigator misses something that the NYPD searcher would have missed as well, right? Like, I'm not guaranteeing that there will be no errors in finding footage because a CCRB person is doing it rather than an NYPD person. But the potential for narrative of a conspiracy where because footage wasn't found during the initial search by the department, do you mind if I finish? That there was that it wasn't that it wasn't found, but there was a deliberate failure to give us that footage. That is a poisonous environment and a poisonous thought that grows, and we can drain that swamp by giving the CCRB direct access.
Thank you.
Thank you. I got a Brewer and then Holden.
Thank you very much. My question is, in how many cases, or is it all, would the footage be helpful, number one? And then secondly, I think you could argue that it might be helpful for all sides because the facts are there. So I'm just trying to get a sense of how important it really is.
So in roughly 80% of our complaints where we have body-worn camera footage, we are able to reach a determination on the merits. That means a complaint is substantiated, found within guidelines, or unfounded. What we have noticed since body-worn camera footage has been introduced, the number of unsubstantiated complaints closed by the CCRB has gone down because we are able to reach a determination on the merits. The number of substantiated complaints has gone up, and the number of within guidelines and unfounded complaints has gone up because we're reducing the number of complaints where we can't make a determination. And we have found body-worn camera footage has been an essential part of that reduction.
Thank you. Councilmember Holden.
Thank you. And Executive Director, you said that 2,000 cases that you can't handle right now. And, you know, there's no funding source, or at least mention of funding on the bill, I believe. So we'd have to negotiate that. How much was your ask in the last budget for funding CCRB, and what did you actually get?
We asked for 50 million and we got 26.
Okay, so that's negotiation with both the council and the mayor's office.
Correct.
So you got half, roughly half.
Correct.
With this bill, if this gets through, you ask for the resources, obviously. You haven't gotten them in the past. And exemption from New York State sealing statutes. Is that ever done?
So there is a bill that the council sent a home rule resolution on to Albany in the last session that actually passed the Senate but did not get out of committee in the Assembly. So I defer to your expertise as actual elected officials on whether it can get passed or not. but I think it's an essential bill for effective oversight of the NYPD by my agency.
And you've gone to Albany to talk about this.
So, no. Yeah. So maybe under the last administration, I might have been to Albany, but we do our lobbying generally has to go through New York City State Ledge. So we have not been asked to
So
go.
if you got the 50 million that you had requested in the last budget, you could actually do this, and not close 2,000 cases.
Correct. I just want to point out that Deputy Commissioner's testimony about the ceiling statutes and how it impacts their ability and how it impacts the nature of the footage. If you're using the law department's definition of body-worn camera footage as an arrest record, he's 1,000% right. And that's why, and because the city has taken that position, we are forced to ask for the state to exempt us from ceiling statutes. But I agree with the lower court cases, and there are no really higher court cases on this yet, that analogize body-worn camera footage to a 911 call. And if the city were to take that position, then we could move forward without being exempt from the ceiling statutes because the ceiling statutes wouldn't apply.
Just a point of information, if you can just tell us, let's say there's multiple officers involved, 5 officers involved in the arrest. You get all the footage, you have to ask for all 5, and do you get it?
So the short answer is yes. Generally speaking, we upfront when we get a complaint ask for waivers, and then we make requests as soon as we can. Now, sometimes our request doesn't get the full results. So we may get footage of 1 or 2 officers, and then that gives us more information that we're able to say, hey, we saw this officer that also had their body-worn camera light on, so can't we get that footage? Or you said there was no responsive footage, but now we have this unusual occurrence report, and it mentioned this officer. Did they have body-worn camera footage? And that will reveal something. Sometimes we'll have an interview, and a member of service will come in and say, yeah, I had my body-worn camera, or my partner had their body-worn camera, and then that's how we'll know. So it's not
So it's complicated. So
Yes.
many times there's different angles that you didn't see and you didn't know existed even sometimes, right? Or another officer from a distance might have had. I'm sure this is a very complicated issue, but the NYPD testified they're doing a better job in getting you the body-worn footage. Is that true?
Yes, the NYPD Legal has been working extremely hard to get us body-worn camera footage in a timely way. The first time, it used to take hundreds of days to get body-worn camera footage. But the department reorganized how they
And that's under Jesse Tisch, the commissioner? Is that recent, or is that?
the hundreds of days is years ago.
No, just under this commissioner. Is it better than it was in the past?
So
under
I think it
previous
is very,
commissioners?
very similar.
Similar, okay.
Because I think it's been between 6 and 8 days for several years now.
Okay, all right. Thank you, Chair.
Thank you for your testimony. I just want to mention for the record that DOI has submitted their testimony.
Can I?
Yes. All right, that now concludes the testimony for the departments. I now open the hearing for public testimony. I remind the members of the public that this is a formal government proceeding and that decorum shall be observed at all times. As such, members of the public shall remain silent at all times. The witness table is reserved for people who wish to testify. No video recording or photography is allowed from the witness table. Further, members of the public may not present audio or video recordings as testimony, but they may present or submit, rather, transcripts of such recording to the Sergeant at Arms for inclusion in the hearing record. If you wish to speak today at today's hearing, please fill out an appearance card with the Sergeant at Arms and wait to be recognized. When you are recognized, you will have 2 minutes to speak on today's hearing topic and the legislation being considered. If you have a written statement or additional written testimony and you wish to submit for the record, please provide a copy of that testimony to the Sergeant at Arms. You may also email written testimony at testimony@council.nyc.gov. That's testimony@council.nyc.gov within 72 hours of this hearing. Audio and video recordings will not be accepted. I now call the first panel.
When you hear your name, please step up. I apologize in advance if I butcher your name. Kathleen McKenna, Jackie Gossagan, and Lindsay Smith. When you're ready, you may begin.
Good afternoon. Thank you for inviting us to speak. My name is Lindsay Smith. I'm a staff attorney at the COP Accountability Project at the Legal Aid Society. Starting off with Intro 1451, we support this bill. Direct access to body-worn camera is critical for timely and accurate CCRB investigations and outcomes. This direct access is not something new. This exists in several other jurisdictions that use Axon as their body cam provider. Those are New Orleans, the District of Columbia, Portland, and Chicago. They all use Axon. They all provide direct access. There are examples of NYPD delaying turning over body cam until the CCRB's statute of limitation has expired, otherwise delaying that turnover. So in the case of Alan Feliz, relevant footage was withheld for over 2 years. In the case of Kowalski Trawick's killing, withheld for over a year. I want to just flag that there's nothing in this bill that requires NYPD to break the law. There is a specific section in the bill, Section 1C, that specifically exempts access that would violate existing law. So this kind of contention that this intro is requiring NYPD to break state law is just not correct. Second, the NYPD has to adjust its policies and its technology to comply with the state law. Right now, there are no barriers with providing unsealed records to CCRB. What needs to happen is the NYPD can do what the commissioner described what the deputy commissioner described up here, which is get that list of sealed arrest numbers and bulk tag those videos on Axon. If there are cases that have this partial sealing issue, that can be dealt with on a case-by-case basis. But what can happen right now with a straightforward technological solution is this access to unsealed body-worn camera footage. May I briefly state our positions on the other two bills? I know my time is up.
Yeah, the time is up. If it's something that can be stated or submitted, if it can be submitted, that'd be great. If it can be stated within 30 seconds.
Absolutely. So we appreciate the intent of Intro 1237. We can't support it as is because of privacy interests. That exact location and age is going to be de-anonymizing for a lot of information. We support Intro 1402. Encourage the council to also pass Intro 1235 on the stated calendar, which would create a new citywide FOIL portal. Thank you very much.
Thank you.
Hi.
Good morning. My name is Jacqueline Guzzi. Actually, it's afternoon now. Jacqueline Guzzi, and I'm Supervising Policy Counsel with Brooklyn Defender Services. I've also been a public defender for over 15 years. We are very grateful to the committee for giving us the opportunity to testify today. Police transparency is an essential measure for holding the NYPD accountable for the discriminatory and abusive policing practices that they employ. As defenders, we see officers with long histories of civil rights abuses continue to police the same streets and harm community members. BDS strongly supports requiring NYPD to provide CCRB with direct access to officer body-worn camera footage. It is important to note here that because the police commissioner retains veto power over any internal findings and recommendations for discipline by the CCRB, there is no meaningful mechanism in place for holding NYPD accountable, but direct access to body-worn camera video footage will greatly assist the CCRB. And NYPD is more than capable of doing this. NYPD has spent millions of dollars on document and case management systems, partnering with companies like Microsoft and IBM. Each of the NYPD's data systems are designed to make the collection and sharing of information, particularly body-worn camera footage, and the kind of information required by New York's discovery statutes, quick, straightforward, and simple. However, even though it has never been easier, there have been infamous delays in their responses to turning over body cam and responding to FOIL requests. Additionally, I want to point out that when a CCRB investigation starts and someone makes a complaint, they sign a sealing waiver. So this argument that NYPD would be violating state sealing laws doesn't apply. I also think it's worth noting here that under that logic, NYPD's own possession of the sealed video footage would be a violation of the law. Additionally, we know that sealed arrest records are part of NYPD's domain awareness system as well. The current level of stop and frisk abuses, combined with a web of NYPD special response teams, task forces, and use of surveillance technology, represents a covert return to broken windows policing, and now more than ever, the city must insist on transparency and hold NYPD accountable. Thank you.
Thank you for your testimony. Any questions? Thank you.
Thank you very much.
Again, when you hear your name, please step up. Dennis Prince Mapp, Bruce Coulter, and Robert Roth.
And you may begin in any order that you would like. 2 minutes.
Done. Mr. Chairman, members of the Public Safety Committee, my name is Robert Roth. I'm a media lawyer and an accredited journalist. I'm speaking here today on the subject of radio encryption, Intro 1460. Everyone in the press corps, I am sure, appreciates Councilmember Brewer and her co-sponsors making an effort to help restore the ability of the press to listen to police communications. Please allow me the opportunity to make several suggestions on how this bill can be even better. In 2023, first, on subparagraph B of this proposed law, I submit that this makes the NYPD have way too much discretion in formulating what their policies could be. In 2023, for example, the NYPD began allowing movies to be filmed with drones, but it still hasn't allowed photojournalists to cover the news with drones. So I recommend these following 4 suggestions. 1, limit the amount of the cost that will be required to listen to the radio. Here is a Uniden Bearcat police radio scanner. It costs about $100. But the NYPD radios cost thousands of dollars. The NYPD can easily require something they want, and then nobody can afford to use it. Next, if they allow something other than a radio, a handheld radio, like a website, it should be able to scan, because you don't want to be able to listen to just one radio station at a time. Finally, if the police are going to be making policies, they should be required to listen to recognized press organizations for input before they make those policies. And finally, please place a deadline for the implementation of this bill. I would like to remind the council that it took 75 years for the NYPD to implement a policy on shooting pictures with drones. I would be pleased to answer questions from any of the members of the committee.
Thank you.
Good afternoon, council members. Please let me introduce myself. My name is Bruce Kotler. I am the president of the New York Press Photographers Association. We are here today to support Intro 1460. The city council should understand the signing. That signing this bill is not an act against policing, but in support of creating greater trust between police and the public. There is a reason that members of the press are nicknamed the Fourth Estate. We are not the enemy of the law enforcement, but a necessary check on potential abuses and corruption. A civil democratic society doesn't destroy these checks and balances, but instead heeds those messengers to make society fairer and safer. The City Council must move forward and sign the Intro 1460, access to encrypted radios. It must be made law for police departments to give legitimate press access to radio transmissions and communications as they have had for decades. It comes down to trust in law enforcement, and the trust has worn thin for many people. It is reflected in the courts where cops are accused of bias, in the streets where officers are treated with suspicion and derision, and will only be maintained, if not worsened, if transparency and accountability are not allowed. Through bills like this, departments have given a long way to establishing trust by using body-worn cameras, but encrypting radios without giving the press access takes away these vital checks and balances that are necessary to maintain credibility and trust in the rule of law. Without the trust, it only becomes harder to do the necessary job of protecting and serving the people of New York. We are not enemies, but partners, fellow servants trying to keep New York City safe. This bill will be a major tool toward the goal. Thank you.
Thank you. I think you have a few questions. We'll start with Councilmember.
One more.
Oh, before, okay. Got it.
Thank you. Good afternoon, council members. My name is Prince Mapp. I'm head of community coach at the Citizen app. I've been with this company since its creation, so at this point you can call me the senior citizen. I say that with a smile, but it reflects 10 years of real work, real service, and deep commitment to keeping New Yorkers safe and informed. I'm here today to speak about the importance of maintaining access to unencrypted radios and what the loss of that access has meant for our ability to support the city and the people who call it home. Citizen operates in 85 cities across the United States, and we are proud partners of Axon, a leader in public safety technology. Together, we help create a stronger, more transparent ecosystem where residents, public officials, and first responders have greater situation awareness, not less. Here in New York City, Citizen has always been an asset, not a liability. We have never cost the city a single dollar, yet we help protect millions every single day, including 50% of New Yorkers who have downloaded Citizen. Our platform real-time impact is undeniable. According to leaders of violence disruptors movement in New York City, Citizen has reduced alert times from 45 minutes to under 90 seconds, contributing to reductions in shootings 63% in New York City. This is a powerful and timely accessible information in a city of this size. For the past decade, we have been part of the public safety fabric in New York City, and in all that time, not a single incident has occurred where Citizen put an officer, a responder, in any harm's way. On the contrary, we receive numerous subpoenas every week from law enforcement, including the NYPD, requesting information, video to help solve cases, locate witnesses, and establish critical timelines. That is a true partnership. Over the years, I have personally met with council members, assembly members, senators across New York State to discuss the Keep Police Radio Open Act. Those conversations were honest, grounded in reality. When information is public, people are safer. The legislature agreed. The bill passed in both houses, proving that transparency is not only important, it is necessary. Today, the bill sits on the governor's desk awaiting a signature. The message from leaders across the state is clear. Keeping information and open saves lives. I don't have time to keep going, right? I just need like 30 more seconds.
Well, we do have your testimony here, and this testimony will be submitted for the record as well.
Okay.
But if you can sum up what you want to say.
Right. So it's simple. allow us to keep doing what we've been doing, and proving that we can do. Be an asset, not a barrier, and keeping New Yorkers safe and informed. The public support this, the legislators support this, and the reality on the ground supports this. When information is open, people stay alive.
Thank you. I'll now open it up for questions, starting with Councilmember Holden.
Thank you, Chair. Thank you all for your testimony. As a former photojournalist in a previous life, I certainly am sympathetic. But I also have to look at the other side. Now, the police are saying that some of the bad guys they've been caught with police radios that you can buy. You used to buy them at Radio Shack, I remember, when they existed. And they were $100, $150. I have scanners. I have two that I listened to, and that's how I knew about what was happening in my neighborhood. Because, and in real time, you know it right away that there's something going on down the block. I listen to Citizen now, I subscribe to that. So is there a middle ground here that we could, because right now the press credentials are very different than when I was operating. You had to jump through hoops to get a press pass. Fill out a lot of forms, or at least prove that you're a photojournalist or a reporter or whatever. Now it's almost like anybody can get it, which I'd like you to comment on that procedure.
Which part exactly, sir? The application process for the press credential?
Both. People now almost everyone with a phone can say they're a journalist and get credentials if they have podcast, their social media. It was much more difficult years ago.
Well, I'd like to address that, if I may, sir, and that is, I have testified at every single hearing, whether from the City Council or the NYPD or the Mayor's Office of Media and Entertainment since 2010. So I am very well familiar with this. Under the settlement that the city made in the case of Martinez Alaquin versus City of New York, the so-called blogger case, the city was required to change the system for issuing press credentials. Now, this has changed a couple of times since then, and under the passage of the bill, Intro 2118 of 2 years ago or so, or 2021, I'm sorry, you can look it up, which created the Mayor's Office of Media Entertainment Press Credentials Office, the rules were changed to allow 6 assignments, 6 covered events within 2 years. Now, there are some issues, and I share with you the concern, as does, I believe, Mr. Kotler, of people who have no news presence. They post things on Instagram or X or Threads or Reels or anything like that, which is not really news media. And you're right, there is a concern, and we've been discussing that, and what to do about it right now, I think, is not within the time limit of this meeting, but I would be most pleased to discuss with you or any members of the committee at some other time what some ideas are. With respect to the use of the radio, could you revise your question again for me, sir?
I'm looking for a middle ground. That means if we
yes.
give...
Yes, may I
Go
address
ahead.
that?
All right.
As much as I respect Deputy Commissioner Michael Gerber, we do know each other, I must vehemently dispute his characterization that all you need as a journalist is to listen to Citywide Channel 1. That is ridiculous. That is just another example of the patriarchal attitude of the NYPD, as in, we know what you need, we know what's best for you. I should tell you that when I was on the street as a photographer, Citywide 1 was not my first primary channel. My first primary channel was actually SOD 1. But he decided for me that that's all I need, so he's wrong. And that's another thing to have to say, as you know right now, council member, the Deputy Commissioner of Public Information in the NYPD decides what they think is worth a news release. I cited an example of this in my testimony 2 years ago that is available in writing. What if they don't decide it's worth a release? What if the police decide, well, this radio transmission doesn't need to be on Citywide 1? Then what? All the journalists are cooked. Citizen is also cooked. They won't be able to hear it. And the public won't know anything about it either, because they said, it doesn't need to be on Citywide One.
Can I give you an example? So my mom was walking to Rite Aid, and there was a person in Rite Aid causing a disturbance. It wasn't a robbery, wasn't a shooting, but the person in Rite Aid was beating people up. That call did not come across the channel, right? And my mom was heading to Rite Aid, but someone actually called me, and I told her, "Hey, Mom, something's happening in Rite Aid," and she was heading in that direction. So everything is not coming across those channels. You know, we are focused on situational awareness, and we want to be looked. So to your point is, we want to be looked at as a trusted source. Not everybody is going to be a trusted source, but we want to be looked at as a trusted source because we've been doing this for 10 years, and we have never put in any officers in jeopardy since we've been here.
Thank you. Thank you, Chair.
Thank you. Councilmember Brewer?
Thank you very much. Along those same lines, particularly on the photo front, because I have gotten a lot of complaints from local media, real media reporters about the same thing. I think you heard me earlier. It's the helicopter above. It's the so-called robbery, which may not be a real robbery, might be more what your mom experienced. I have store thefts many too often. So what would you suggest, along with Councilmember Holden, would be the encryption policy? What would you suggest would make more sense than just Citywide One?
If I may respond to that, thank you for the great question, Councilmember Brewer. As I noted 2 years ago, the NYPD is probably, other than the military, the biggest customer of Motorola in America. And the NYPD could easily say to Motorola, make us a batch of radios, and we want to get rid of the transmit function in them. There should be no transmissions, but we want to have the ability to receive. And we want to have the ability to decide which frequencies will be received. And because all those radios have electronic serial numbers, we can decide who's going to get one. The NYPD could loan them out, lease them out, maybe even authorize people to buy them. And that way they can control that. And also the great thing about this is their big concern, what if the unauthorized transmissions are made? Well, they would know exactly where they're coming from. I don't know. I don't have an electronic engineering background, so I couldn't modify such a radio, but they could, and they would know where they're coming from. I will attach to my new written testimony a copy of my previous written testimony, so you have that as a reference point. They can do this. Currently, I have researched, I went to Uniden, the manufacturer of this popular scanner, and they said they have nothing that they could sell us because of encryption. So it is very hard to find a radio that we could use, but I share with you the concern that we can't just have one channel.
Good. In terms of photography, is that something, tell me how you're, in a sense, is even more challenging for the photojournalist.
I've been a photojournalist for 43 years. I started out with Radio Shack scanners, moved along. Now I have a group of photographers. We all talk, and when we hear, it's kind of like a chain. That's how we find out. Give an example. Last night in Bay Ridge, call came over, police need assistance. That was it. It turned out ICE was in the neighborhood. They were looking for someone. There were residents in the neighborhood that were getting rowdy. It never came over. A neighbor called called someone. They called someone, and that's how it got. Terrible. It's just
So none of that would be on Citywide One?
no.
Because it doesn't.
Then also Monday. It was late Sunday night. I think it was like 12:43 in the morning. Person was shot in, I think it was Brownsville. The police decided to drop a sheet, as we call it, on Tuesday morning.
No
Hours
photos
later.
there. No photos there.
Nothing. They're trying to direct the narrative. Can't be. They can't tell us what we can cover. We have to decide that.
Real examples are helpful. Real
And
examples.
I'll get you plenty.
That would be helpful. Real examples would be helpful.
You can.
Councilmember, can I add something to that? So the Department of Justice sent out a memo saying that cities should go encrypted, but it was clear that they said that we should deduct PII, personal information. And that was the main reason why encrypted was actually brought into existence, because they didn't want people's personal information out there. We've used technology, we use human beings and AI to make sure that we detect any personal information. Along with Axon and the technology that we've been using, this change can be done in a week. It's not going to take 10 years like the Deputy Commissioner was mentioning. This can be done in weeks if they have the right acts. If they really wanted to de-encrypt, which they spent a lot of money to encrypt these radios. And then to your point, the reason why you're not hearing anything in Brownsville because certain areas of New York City went encrypted first. Brownsville, Brooklyn, East New York, the Bronx, the areas where most of the things are happening the most, that's where you're not hearing anything for. And these are where we were keeping people safe. As I mentioned in my testimony, we are 63% in reductions with shootings in certain areas where we have the information.
My friends are concerned because they want to keep an accurate count in a neighborhood of what crime exists. And they're feeling as a reporter, these are the local reporters, they can't do that because they're not able to have the actual information. So that's another, how do you keep tabs on the stats if you're not able to have the info? That's what another concern that I'm hearing about, like long list of them.
Mr. Chairman, I know you're pressed for time, and I just want to add one statement to sum things up. Contrary to what the police department said, particularly when former Chief Beltran testified 2 years ago, we are not the quote-unquote bad guys. In fact, I challenged the NYPD 2 years ago, and I repeat this challenge today. Police radio scanning has been in use by the press for decades, at least 6, maybe 7, maybe more. Please show me one case of where an accredited journalist was found to have used a police radio scanner in the commission of a crime. So far, they have never come up with one. Forgive me. So I repeat the same statement. We are not the quote-unquote bad guys. We are being profiled.
Understood. Well, thank you. Thank you for your testimony.
Thank you,
That
sir.
concludes this panel.
Thank you. For the next panel, if you hear your name, please step up. Apologize if I pronounce your name incorrectly. Amari Duardine and David Siffert. You may begin when you're ready.
Good morning, Chair Salam and members of the Public Safety Committee. Thank you for having us at this hearing. First on 1402, this is a very important bill for STOP. We file a ton of FOIL requests, especially at NYPD. It's not atypical from when we originally file a request to when we finish getting completion of documents turned over. It could be 4 or 5 years. By that time, the information is stale. That should give you a sense of how important it is that we get this kind of information. Second thing I'll say is that NYPD is actually not the worst agency in New York City, believe it or not. The Office of the Mayor, for example, has worse response times than the New York City Police Department. As a result, I think what's really important is what's on the stated calendar for next week, Intro 1235, Councilmember Brewer's bill. Getting that passed would make a big difference because it would cover all New York City agencies and require broader reporting. But I do think that 1402 is particularly important because it requires DOI recommendations on NYPD reform, which we've seen with respect to the Post Act can make a big difference in terms of shaping policy in the city. Next, on the CCRB camera footage, STOP has long taken the position of skepticism towards body-worn cameras because they can be used selectively by the New York City Police Department to shape narratives in ways that favor them. A 2016 study by George Mason University found that 8.3% of offices and jurisdictions with body-worn cameras use them to prosecute police officers, and 92.6% use them to prosecute private citizens. So these cameras are much more likely to prosecute private citizens than they are to prosecute police officers. This is in large part because of the flexibility of the police department selectively to release information. The second thing I want to say here is to contradict something that the Deputy Commissioner for Legal Matters said. It is not the case that it is illegal for NYPD to disclose to CCRB sealed footage. What is illegal is for them to possess it in the first place. So what they're worried about here is not that this is going to require them to break the law, but rather that it'll disclose that they're already breaking the law by illegally possessing sealed video footage. And then very quickly on radio transparency, first, we've had unencrypted radio transmission for decades. including some of the lowest crime rate time periods in New York City. I have not seen any justification for moving to encrypted transmission, but if we do, this bill is really important, 1460. Not only does it do some of the things that the state bill, which passed this year and is awaiting the governor's signature, does, but it also requires disclosure of this information to the general public and not just journalists, which is very important. Thank you.
Thank you for your testimony.
Good morning, members of the Committee on Public Safety. My name is Amory Dujardin, and I'm the Policy Manager at Citizens Union. I thank you for the opportunity to testify today. 2 years ago, Citizens Union testified in favor of Intro 1451, under a different number then, and today we'll do the same, largely with the same testimony and updated data. While CCRB's access to body-worn camera footage seems to have improved, Citizens Union believes that it is best to codify the board's access to materials into law so tactics intended to undermine the charter and the investigations into misconduct do not return under different leadership. Pursuant to the New York City Charter, the Civilian Complaint Review Board has the power to compel the attendance of witnesses and require the production of such records and other materials as are necessary for the investigation of matters within its jurisdiction. In the past, however, the New York City Police Department in practice withheld significant relevant information, especially apparent in the use of body-worn camera footage from the CCRB, or produced it after substantial delays and often with redactions. The CCRB has cited its inability to complete investigations of complaints with getting BWC footage, including delayed responses, false positives, false negatives, and inconsistent responses by the NYPD. This bill would streamline investigations and ensure there are no roadblocks in access. Obtaining footage allows the CCRB to resolve conflicting testimonies and receive a clearer interpretation of the circumstances of an encounter. They have been especially effective in getting fully investigated complaints closed on the merits, allowing the CCRB to determine whether an officer's actions are misconduct. CCRB data continues to show the rates of both substantiated and unfounded findings significantly increased in investigations with BWC footage. As mentioned, there has been notable progress made in providing the footage, but the best way to ensure the continued safe and democratic application of policing is to strengthen and streamline systems of oversight and accountability. The CCRB should have prompt and full access to footage from body-worn cameras and all other NYPD documents and materials relevant to its investigations. Thank you.
Thank you.
Thank you all for your
Thank you for your
testimony.
testimony.
Before I turn to the last person, if you're here to testify in person, please sign in a slip with the Sergeant of Arms at the back. When you hear your name, please come up. Christopher Leon Johnson. You may begin when you're ready. After that, we will turn to Zoom.
Okay. Hello, Chair Salam, Chair Holden. My name is Christopher Leon Johnson. I'm here to show opposition to Intro 1460. And the reason I'm opposed to this bill is because of the fact that in the past 4 years, ever since the 2020 settlement, the city has given the wrong type of people press passes. I think Bob Holden knows who those names are, of who they give those press passes to, and those people should not be given access to the radios, because what they do is they relay those information to some of the worst type of people on X and social media, and they make this whole city look bad. They make it look like the city's on fire. Now, in 2026, we have a new mayor, which name is Mr. Zaran Madani. And like I said, even this bill get passed in the city council in December, he's going to veto it because he's going to be the root of like the crime in the city. And he doesn't want his name to look bad. And we all just found out today that the commissioner will be the new commissioner under administration. So they're going to do whatever they got to do to bury this bill. And like I said, even this bill get passed, this bill is going to get vetoed by Mayor Madani, because you have 30 days after the day, unless you do it the 25th, it's going to die in January. But I want to end this here with the bill for Arjeen Adams about the cameras. I want to be opposition to that is because of the fact that we have to protect certain people in the city, like domestic violence victims and people that just don't like being on camera, even in a public place. I'm a journalist myself, and I'm in a public street. There are people that get mad at me for recording them in a public place. So it's like, but you start finding out, oh, they're domestic violence victims, they're immigrants, they're migrants. They don't want to be on the camera. So you have to look at that side. Like, what about the people who don't want to be on camera, who don't want their stuff to be publicized, especially you don't know who's going to be watching that stuff at CCRB. So it's something where that, look, I understand that this stuff's on the table. This is the last, 3 sessions left. But the intro 1460 is not. I don't think it's good happening right now because the wrong people got the press passes in the city. It should not be going through. I'm not saying names, but we all know who they are who shouldn't have a press pass. If, like I said, the city council introduced a bill to where it's like the city council should decide who gets their press pass revoked. There should be a hearing like, get all the names of people that have a press pass and start revoking them one by one. Because once you start revoking certain people press passes from the far left to the far right, and we all know who they are. We all know who the names are in this. And I'm not saying no names. We all know who they are in this politics stuff, right and left. Maybe bills like this will be sued for the public. So, like I said, the wrong people got the press passes right now in the past 4 years, and this is not good. You can't. Not everybody's a journalist. You got reactionaries and Antifa folks who got press passes, and it's not correct. It's not right. I don't have a press pass. I know what's going on. I'm not mad about that, but there's many people I could give you a list who should get their press pass revoked. But Intro 1460 is not right with these people having with press credentials in 2025 and 2026, and they're gonna get their press pass renewed in 2027. Should have press credentials. Unless you, like I said, Salam, you introduce a bill to make where the city council have the right to get involved in revoke passes like you did, Mr. Cole. Let me revoke John Rinaldi's pass, which is great that you did. This is not right. So thank you so much and enjoy.
Thank you for your testimony.
Thank you.
Thank you for your testimony. Before I conclude in-person public testimony, is there anybody left here that would like to testify in person? Seeing none, I'll be turning to Zoom. When you hear your name and you're unmuted, please begin. Dr. Tawana Guilford.
Hello. Good afternoon. My name is Dr. Tawana Guilford, and I am a licensed psychologist and an individual impacted by an unfulfilled FOIL request. First, I would like to thank Speaker Adams, members of the council, the chair of the Public Safety Committee, and the legislative staff for all of the hard work you do to keep the city moving forward. I also thank you for giving me the opportunity to testify. I join you this morning to express my unequivocal support for the amendment of the Administrative Code to enforce compliance with FOIL requests, also known as Intro 1402-2025. As a family member of an individual who was wrongfully convicted at the hands of two officers with questionable histories, I know the detrimental effects of not having access to exculpatory evidence that could have changed the trajectory of my relative's criminal conviction. Had our FOIL request been complied with, then a jury and judge would have had access to information that would have cast doubt on the officer's credibility. In our specific case, officers' records were requested but shielded due to the privacy of disciplinary records. It was not until the passage of the law to repeal 50A that gave the public access to CCRB complaints that had been lodged against the officers. To date, we have not received, but would like to obtain disciplinary records of the arresting officers to learn why the officer in our case was 1, transferred to 3 different units within a short span of time, 2, may have possibly been demoted from a special unit back to becoming a patrol officer, and 3, may have been possibly placed on desk duty during the last year of employment prior to his early retirement. In closing, I would like to state that while this amendment may not help my family to get the closure that we have been longing for since 2013, having enforcement of the law may certainly vindicate others who may be at risk of experiencing a wrongful conviction at the hands of bad actors in law enforcement. Thank you for your attention. I yield back my time.
Thank you for your testimony. Next is David Donovan.
You may begin.
Yes, thank you very much. My name is David Donovan. I'm president of the New York State Broadcasters Association. Trying to get a video. Yes, president of the New York State Broadcasters Association. Thank you for giving me the opportunity to testify today. I represent radio and television stations across the state. I also organize the Broadcast Emergency Alert System for New York State and have worked on spectrum management in a former lifetime down in Washington, including police spectrum management. We support 1460. We have testified 2 years ago on this issue. This issue began back in February of 2023, where we presented NYPD with a plan to allow journalists access to police communications. The fundamental issue here, and the biggest concern is for both police and the community, is that right now, the only way citizens can gain access to information about police activity in certain areas of the city is they get it by mobile phone. They get it by a bystander. And that can often present either intentionally or unintentionally, a biased version of what the police are actually doing. So I truly believe that having and allowing journalist access in real time is exceedingly important. In the 90 years since we have been dealing with this issue, there's not one example of a journalist having access that's caused any problems or harmed any law enforcement officer. Let me address, if I may, the statements that were made earlier about shifting unencrypted communications to Citywide 1. That's a huge shift in position, which, by the way, is a step in the right direction. But it doesn't go after the real problem. The reason why you have an architecture which is based on precinct, borough, and citywide is because if you have all police communications that are important,
your time has expired. Thank you.
Go up to City 1. Let me just finish, please. Go up to City 1. It can't handle it, which is why they went to this architecture in the first place. So color me skeptical as to allowing the police department to determine that this communication goes on City 1, but we're not going to allow other local information to go on New York City 1, thereby keeping the whole system encrypted. Thank you very much.
Thank you for your testimony. Next up is Todd Mazel. You may begin when you're ready. Thank you.
Okay, my name is Todd Mazel. I'm a founder of the New York Media Consortium, which includes 15 organizations now, all press organizations. I want to address some of the things that were mentioned by the police representative. Firstly, privacy concerns. They're unfounded because all private information is sent to their central command via telephone. They all have phones. Secondly, they don't put over fatal crashes. You'll never know if there's a bicycle crash or somebody was struck by a vehicle. They don't put it over. They decide what is important. So not all homicides are broadcast. Also, ongoing incidents are not updated. Particular injuries not updated. We don't know what is actually going on in some of these incidents. There may be one person, maybe two persons shot. We don't know. They're putting over whatever they decide is the news, whatever is the narrative. We need the press, and I've been a member of the press for 40 years. I've been listening to radios my entire life during that time. And I got to tell you, one channel for us to listen to that they decide is the news is just wrong. It's totally wrong. And it needs to be corrected. And we support Gail Brewer's amendment here. Also, just as an added, I have 20 foils out with the NYPD that have never been satisfied. Some of them have been rejected. I have one with the Office of Information Technology because we suspect that they've been using their budget to supplement the NYPD's budget on communications. Every month I get an update for the last 2 years that they're still trying to get the information that I'm asking for. 2 years. So your FOIL legislation is also very important. Thank you.
Thank you for your testimony. That concludes the Zoom portion of public testimony. We will be going back to public testimony for one last in person. Thank you. We'll now call Richard Flores. You may begin your testimony when you're ready.
Hey, thank you for giving me the opportunity to testify today. Beginning in 2016, I have repeatedly reported many incidents of gross police illegality and misconduct by the NYPD to the CCRB. Incident reports have included illegal false arrest, detainment at 1 Erickson Place precinct, and at the Manhattan Detention Complex. I have repeatedly reported the failure of the Department of Investigation by a deputy investigator, a Leslie Boudel, whom I spoke with, and a policy director whose name is Dean McKenzie. Also, investigators at the NYPD Internal Affairs, the last phone call that I received was by a Sergeant Lee, whom, after I called him, never returned my phone calls. All the officers at various precincts, particularly Midtown Precinct North, the 20th Precinct, and the 105th Precinct in Queens Village, where my family lives, to report various crimes that have been committed against myself and my family. Crimes ranging from attempted murder, physical and mental abuse, rape, theft of property, slander, and defamation of character, that to this day have not been officially investigated by the NYPD or the CCRB, as far as I know, or any city or state judiciary with regards to any of the crimes that have been committed against myself and my family. In addition to filing incident reports to the CCRB in 2021, if you recall, 2 New York State investigators from the Bureau of Criminal Investigation interviewed me at the YMCA Vanderbilt BRC concerning my complaints of corruption and illegality that was occurring there, which resulted in a cover-up and suppression of evidence, including surveillance video of all crimes occurring at the BRC facility, which has continued to consistently, for over 4 years, continue this behavior by what I understand to be volunteers, some who have felony records, security that work there, allied security, and civilians who enter the facility without my consent and the security's consent. I will go further to say, yes.
Recognizing that your time has expired, I do have a question for you.
Yes, Mr. Sloan.
Because of the nature of your testimony, do you have legal counsel?
I've tried to get legal counsel, and I've not been able to successfully get anyone to take my case. The last time I went to a legal office was in Queens about a month ago. My mother actually told me to go to this office and see if they could help you. So I went to the office. I went through the list of things that they help people with. They don't help anyone in terms of housing. They said, "Sir, we don't take housing cases here." The only thing that they took cases for.
I mean, you mentioned some pretty serious other allegations as it relates to the nature of your testimony, and I'm thinking that relying on the CCRB to investigate those particular things and bring forth said charges might not necessarily be the right, so to speak, avenue. That's why I asked if you have legal counsel regarding those. Like you mentioned, some very, very serious allegations, and so I do want to perhaps maybe capture the rest of your testimony. If you can send that to us via testimony@nyc.gov or counsel.nyc.gov. Just because of the nature of the time has expired for your verbal testimony, but we definitely will take written testimony from you.
And would I be able to get anyone from City Hall to help me with getting legal counsel to start a case?
You're in Queens?
I'm in Manhattan.
You're in which district?
Well, 47th Street. I don't recall the district offhand.
So then we just may, what we may have to do is circle back offline to connect you with your council member so that they might be able to help you with what you need in terms of remedying your situation.
Okay. So what would be the process at this point to get legal?
Oh no, you can just sit right there after you finish, and I'll try to connect you with the right resources that you need.
Okay.
Absolutely.
Okay. Thank you.
Thank you.
Thank you, Mrs. Salam.
Thank you for your testimony. Next up, Tito. You may begin when you're ready.
Thank you for your time there, Mr. Salam. I appreciate it. I came here last time. For years, I've been asking for assistance and help because I was attacked and terrorized by law enforcement in 2 different states. I can't get police reports. I am unable to get a job. I've been stalked and followed around. When I tell law enforcement I'm being stalked and followed around, they are refusing to take a report. I was assaulted with a deadly weapon. Again, they keep refusing to take reports. So it seems like law enforcement is behind it, who is attacking me. So I need some assistance. This has been going on for years and years and years. And I put my evidence up online. My car being sabotaged. I'm being assaulted. Like these things keep going on. So again, if I'm executed, my evidence is online that these things are happening to me. They could pretend that it's not happening to me, but I put the evidence up there. So I'm trying to get police reports. They're hiding that. I'm trying to get an investigation. Just been going on for years. I'm still being terrorized. I'm still unable to find a job. I get a job. I start, then they change their mind. I get a job, work there one day, then they change their mind. I get another job. I start. They say, okay, come start. I go, oh, okay. I changed my mind. So I'm being followed around. I say by corrupt people in law enforcement. So that's why I keep asking for an investigation to go on. Excuse me, and also police reports. Since I was assaulted, I'm trying to get police reports. That's been going on for years and years and years. That's what I have to say. I need some assistance.
So I'm not sure if you came in while the previous person was testifying as well. What council district are you in?
I'm not sure, but I'm in Queens. Since being terrorized, I'm not sure. Queens, I know. So, what side?
All right. So the best course for you also would be to connect you with your council member to figure out ways forward, because the type of assistance that you need really has to be local.
Okay.
Yeah. So if you stand by after, the time is expired as well. But if you just stand by for a moment, you can sit back in your chair, and I'll see if I can get some resources your way as well.
All right. Thank you.
Thank you.
I appreciate it.
Thank you for your testimony. It's the last call for in-person. Last call for Zoom. Seeing no hands on Zoom, that's the end of public testimony.
Thank you. That concludes today's business. This hearing is now closed.